Right, good morning, ladies and gentlemen. Welcome to this, the 28th meeting in 2013 of the Economy, Energy and Tourism Committee. Can I remind everyone present, please, to turn off or at least turn to silent all mobile phones and other electronic devices so they do not interfere with the sound system. We have apologies this morning from Marco Biaggi, and we're joined by Joan McAlpin as his substitute. Right, item 1 on the agenda is our continued scrutiny of the Bankruptcy and Debt Advice Scotland Bill at stage 1. We have our first panel, introducing from my left-hand side, Frank McKillop, who's Policy and Relations Manager, Scotland Association of British Credit Unions Limited. Maureen Leslie, Council Member of the Insolvency Practitioners Association. David Hill, who I think we saw just last week, Partner BDO LLP, who's previous ICAS Insolvency Committee Chair, and Eileen Blackburn, Partner French Duncan LLP and Chair R3 Scottish Technical Committee. Thank you all for coming along this morning. I think you've agreed in view of the time we're not going to have opening statements from you. We've got your written submissions, which members have read and which are very useful. We are a little bit tight for time this morning. We've got 2 panels to get through before 12 noon. So I'd ask all members if they would keep their questions short and to the point, and if we could have answers in the same vein, that would be very helpful. And because we're quite a big panel, I think rather than just have questions thrown open to everybody to answer, in which case you'll all want to have your say, I think it'd be easier if we can direct questions to a particular witness, and then if you would like to respond to a question that's gone to somebody else, if you just catch my eye, I'll try and bring you in and let you have your say. Okay, can I maybe just start off, having read the written submissions, clearly one of the issues that is of concern to a number of you is this question of the accountant in bankruptcy reviewing her own decisions and whether that's an appropriate balance and will provide an appropriate level of scrutiny. I maybe start off from Maureen Leslie, because I think this was in your submission from the Insolvency Practitioners Association. Can you outline what exactly your concerns are about this situation? And if others want to come in and add to what you've said, I can bring them in.
The concern basically is that it's a conflict of interest, and that no matter how much effort is put into the separation of functions, inevitably it is one decision-making body which will be reviewing its own decisions. And currently that's a matter reserved for the court, which is clearly an independent, brings independent scrutiny to the decision-making process, and we feel that independence would be lost if those proposals were to go ahead.
Or Ms Blackburn, would you agree with that general position?
Yes, I certainly would, and I think, as I said last week, again, it's the perception, if not even the reality, the public perception, I think, would very much be there's too many legs to the accountant bankruptcy when they're reviewing their own decisions.
Okay. Ms Blackburn.
Yes, just picking up on that, we would have concerns that civil servants are not in any event qualified to act in what is essentially a quasi-judicial role, and to an extent usurping the role of the court.
Mr McKillop, the Association of British Credit Unions seem to take a different view on this from your fellow panellists.
Our position is that we certainly value the opportunity to challenge decisions or to challenge proposals to trustees, for example, that we don't feel are fair. So our idea in the original consultation process was for an independent review panel to be established. We understand the argument against that, mainly in terms of cost, but the cost of going to court for a creditor is also significant, especially credit unions. Credit unions don't have the budget really to be pursuing court action, so we certainly value having a review function. Our idea was for that to be completely independent, but we are satisfied to at least see how it works out as being part of the AIB's compliance unit. Okay,
I could maybe ask Maureen Leslie, would an independent review body, would that satisfy you, or do you think it needs to be left to the courts?
It has to be left to the court. I think that Mr McKillop and I are perhaps coming at this from a slightly different approach. Mr McKillop mentioned a review of the grant of a trust deed or a trust deed becoming protected. In this particular case, we're speaking about removal of functions in a bankruptcy and taking them away from the courts and leaving them with the accountant in bankruptcy and leaving her to review those decisions. Some of the matters referred to in the bill are in fact extremely complex It's set out in the bill that the matters that should be removed from the courts are administrative in nature. And they give, for example, as an example, an application for directions which a trustee can make on quite complex points. Now, just to make this perhaps more real for the committee, most people, I think, would be familiar with the application brought by the administrators of Rangers Football Club for directions in the matter of the
Very
claim.
familiar with that.
I thought you might know that one. It was an application for directions on how to deal with the claim by Ticketus. Now, albeit that's in a corporate insolvency process, that is typical of the kind of questions upon which a trustee in bankruptcy would also seek directions. Ultimately, those are questions which really have to be decided by the courts. And we question significantly that the EIB would ever have the level of expertise that would satisfy either the trustee or the creditors concerned.
Does anybody else want to come in on this point? Mark McDonald, do you want to come in on this issue? Right, okay. Dennis Robertson.
Yeah. I'm just interested in the fact that you tend to think, I'm trying to remember who said it, that the civil servants don't have that necessary experience or level of experience in terms of dealing with legality matters. Surely within the civil servants and within AIB itself, they will have people who are probably well qualified in legal matters. They may not be operating through the courts, but did you not accept that they probably do have maybe that level of knowledge and experience? Maybe Maureen Leslie first.
Certainly there's people there who are greatly experienced, but they're not necessarily legally qualified. In fact, I'm not aware of anyone within the office of the AIB who is a qualified solicitor. But in any event, the application for directions is heard by the sheriff or a judge. So I do question whether that level of legal expertise is available within any civil service department.
Mm-hmm. Mike McKenzie.
Yeah, I was just interested in the example that Maureen Leslie used about Rangers Football Club, but I don't think this bill doesn't deal with commercial bankruptcy as far as I'm aware, does it? Or am I getting this wrong?
It deals with all bankruptcies, so bankruptcies, there would within this fall within the consumer bankruptcies, but the same legislation applies to business bankruptcies.
But not all cases will necessarily be as high profile or as technical or difficult as the Rangers example that you gave.
That's right. The vast majority won't be that difficult. But the issue is that in the vast majority of cases, there's no need to apply for directions. The application for directions, for example, would only come in complex cases. They're rare, and they do relate to complex matters.
Thank you.
Yeah, no, I would just agree with that completely. I mean, the bill deals with all personal bankruptcies. As Maureen said, the vast majority, except our consumer bankruptcies, and in 99% of them, you would never need to seek directions. And you only, as Maureen did say, you only need to seek directions in complex matters. And it's usually, there's also the question of speed, that you usually need to have a quick decision. Again, I think this was very similar, and therefore straight to the court is seen to be better. And I think I would also add that we're not against the AIB, getting certain extra things. There's quite a few things in the bill we do agree with. The recall of sequestration, where there are sufficient funds to pay creditors. Very much agree with that. It should go to the AIB. So it's not a blanket. We don't want the AIB to do things. It's in certain instances.
Mr. Hill, you were saying that, obviously in terms of court and it's speedy. The courts not slow up the process sometimes?
They're usually good at dealing with urgent matters that they can deal with quickly. I mean, I think it's known that courts can be very slow for general matters, but I think we find when you need a quick decision on these sort of things, you usually are able to get into court quickly and get a quick answer.
And there's basically, you believe it's a conflict of interest with AIB doing their own sort of reviews at the moment. Is there anything there that gives you any reassurance from AIB that they would, in some respects, I'm not quite sure we can use the word independent panel, but certainly a panel that would be removed from the original decisions?
Yes, I mean, I do accept that there would no doubt be different individuals that would review decisions that had already been made, but I think, as I do remember saying last week as well, that there's always the temptation that if it's people within your own organisation that have made that decision, there's a sort of inherent, you're starting off from the point of view that it's probably right, and you're looking for something that's wildly wrong rather than just a totally independent view. And again, as I say, public perception, someone in their own organisation reviewing it doesn't seem in the face of it to be independent at all.
Is that public perception being fuelled to some extent with people who don't agree? Like
Possibly.
yourselves?
Yeah, it's possible. I suppose.
Okay, Alison Johnson.
Thank you very much. On the same issue, I mean, it seems that only the Association of British Credit Unions look at this as a possibility that they would favour, although you do suggest that an independent review panel would be a good idea. So there's obviously a lot of concern here. I just want to is it your view that the driver here, that the rationale for this change is simply to save money, or are there other good reasons that this would be a proposal?
If I may, yeah, I think there are good reasons for doing it. The courts are extremely busy, and where possible, removing administrative processes from the courts is to be welcomed. And I think we have said that the removal of the application for recall of sequestration and allowing that to go to the accountant in bankruptcy where the recall is on the grounds that the person has sufficient security to pay the debts in full, that's fine. But some of these other matters are not, they're neither simple nor straightforward, and they must, no matter what the cost, they should be heard by an independent justiciary and not by a civil servant or a public body.
Okay, thank you. Does Eileen Blackburn, do you have a view?
I mean, I think what I would like the committee to take from this is that we don't seek directions lightly. I mean, only in the most complex of occasions would we be going to the court for directions, because ordinarily we have recourse to legal advice and we have our own expertise. So it would only be in very exceptional and complex cases that we would seek the directions of the court in any event. I would further make the point that it would seem iniquitous to me that a liquidator would have access to the court process in seeking directions where a trustee in bankruptcy under these proposals contained within the bill wouldn't.
Okay, thank you.
Jill McCullough, do you want to come in on this issue? Or?
Not particularly on this
Right,
issue.
okay,
no.
I'll come back to you then, because I think
Yes.
you were on this issue.
Yeah, I come back to the point I made last week. Good morning, by the way. We seem to be losing sight of what we're trying to achieve here in terms of looking after the interests of the debtors and the creditors. And I get this feeling, and it's partly out of experience, that if we go through some of the process, even the complex ones that you mentioned, that the beneficiaries tend to be the insolvency practitioners, the lawyers, the courts. I mean, where in your judgment does that kind of activity stop and we start considering the debtors and the creditors? There seems to be an opportunity for some people to make a lot of money giving advice, and in some cases unnecessarily extending that advice on the basis of the income that accrues to them. Is that not the case? Who's that? Maureen Leslie.
No, I would disagree. I don't disagree that in some instances that lawyers can make a lot of money in this, but I certainly would never take an application for directions or issue with some of the other matters here, valuation of a contingent claim. I have got no, well, I do, I guess, in that I charge my time, but I would never take those applications simply for the purpose of running up time costs. At all times, my concern there is, as a trustee and indeed as a liquidator, would be to look after the interests of creditors. And, for example, in the valuation of contingent debts, it can make a huge difference in the outcome to a case. These claims can be significant. I'm dealing with a bankruptcy just now where I have contingent claims, one for 200,000 and one for 210,000. Now, if I were to admit those claims, the dividend to ordinary creditors reduces to something like 2p in the pound. But if I can deal with them and have a judicial decision on whether or not those should be admitted, and if so, at what level, then the dividend, provided they're not admitted in full, is significantly improved.
But that dividend, isn't it, Ms Leslie, affected by the fact that one of the first fees to come out of whatever pot is available is that of the practitioners, and they're not inconsiderable.
You're right that the first thing to come out is the practitioners' fees. In not every case are they considerable fees. The average fee in a sequestration.
Well, in relation to the amount of debt, I would suggest that they probably, in most cases, they are quite considerable.
I simply don't agree.
Okay. Thank you.
Yeah, I think it's just to pick up on that point. It's certainly the reason that credit unions have taken such an interest in the bankruptcy issue and bankruptcy reform is because credit unions are finding that exactly as you expressed, that creditors seem to be at the back of the queue when there's an insolvency, and I think it's what we welcome in the bill is rebalancing that so that creditors are hopefully going to receive a higher dividend wherever possible from trust deeds or bankruptcies and other solutions. So I think it is that feeling of rebalancing it. I think, as you said, where creditors are at the back of the queue, there's credit union examples where there's been a trust deed of £5,000 where the debtor's been able to pay £150 a month to that, but the credit union didn't get a single penny from it. And I think that there's concerns about that do need to be rebalanced. And I think any measure in this bill which is going to reduce the costs for creditors and ideally improve the possibility of a better dividend is something that we would welcome.
Thank you.
John McCall, sorry, David. Yeah, David Hill and John McCall.
Could I just make a point on the bankruptcy fees, just in case the committee are not all aware that in all bankruptcies, unlike trust deeds, which is a separate issue, all bankruptcies, the fees are audited by the accountant in bankruptcy. So there shouldn't be any excessive fees going through at all. They should be cutting any fees that they view as excessive. So that's a big difference from trust deeds, that in bankruptcies they're all audited.
Okay. John McCall.
On that point and the point that Mr Brodie raised, at the height of the UK recession in 2008 to 2009, the UK's top 10 accountancy firms made 20 billion, and 8 billion of that was in pure profit, largely from their insolvency divisions. I'm struggling to see how in that case we can't say that there might be something wrong with the system and that people are making too much money out of insolvency.
I would try and answer that. I'm not sure that it would be true that it would be largely from insolvency. I think that's probably not the case. If you're to drill down in it, they don't usually release the division of their profits between their various divisions. But the major accountancy firms are very, very substantial businesses, and not here to defend the amount of money that they all make, but they employ a huge number of people, and mostly come in as the top graduate employers and all these sort of things. So they have to pay people the rates that are appropriate for the jobs that they're doing.
Do you think that's why Deloitte's made 40 millions from this insolvency of Woolworths alone, for example?
Well, I mean, I'm not here to defend a particular case, but Woolworths is obviously a complex case, and there's been, they would have again to get their fees fixed in that case. So they were able to justify that they got those fees. It does seem high, to the man in the street, as it were, but it was a complex case. These are extreme examples of the vast majority of cases. The fees are nowhere like that, and in Scotland there wouldn't ever been a fee that size.
Okay, Mr. McCall.
And I think from a credit union perspective, we recognise there are costs involved in any insolvency. We recognise that, and we've got no objection to anyone getting a fair day's pay for a fair day's work. I think the problem we have is who decides what a fair pay is. It looks from our perspective in some cases like they're getting a fair week's pay for a fair day's work, and it seems to be the problem there is how are the fees set. And I think, again, coming back to the idea of rebalancing bankruptcy and insolvency legislation, is no one seems to have a regard for what's fair to the creditors here. If the creditors get very little or indeed nothing at all, you know, it's perfectly fair for the insolvency practitioner to collect a fee for their work, but how is that balanced with the fact that a creditor, including a small community credit union, can come away with absolutely nothing in many cases?
Yeah, this is quite an interesting discussion, but it's slightly tangential to the purposes of the bill. So, I mean, unless members are desperate to come in with additional points, I really think we probably need to move on and discuss wider matters.
Just one,
Yeah, Mr. Brody.
Can you tell me what obligation are insolvency practitioners under to keep timesheets of the work that they do?
We are obliged. It's quite simple.
Who checks them?
When
Who validates them?
we record our time electronically. So when you spend the time, the staff record how much time they've spent. When we make an application in a bankruptcy for approval of our fees, we're obliged to give those time records to the accountant in bankruptcy. And every 3 years, my regulator, well, the IPA, will come in and regulate its own practitioners, and they will spot check files, and they review the primary time records. They insist on printouts from your time recording system.
Okay, thank you.
Okay, I think we really need to move off the question of remuneration of insolvency practitioners. I think Mark MacDonald, it's your turn.
Yeah, I want to look at the issue around financial education, and I think it would be fair to say that the views on the panel before us range from outright opposition to qualified support, with a little bit of scepticism thrown into the mix as well. If perhaps I could turn first to Eileen Blackburn, and in your submission, you state, we do not support the policy that discharge of the debtor is linked to financial education. You also make the statement or the assertion that you believe that most debtors can budget. I wonder if you could give some rationale behind why you don't feel that financial education should play a part in the process.
We're not against financial education per se. I think what we're saying is that we don't think it necessarily ought to be linked to the discharge of the debtor, because there will be cases where debtors have found themselves in financial distress through no fault of their own and not through any deficiencies in their own ability to budget. I mean, people quite simply in some cases don't earn very much money, and they have living expenses which they have to meet, and very often these living expenses we find are subsidised by resorting to credit, sometimes at very, very high interest rates, as we all know. So we think that it may be appropriate in some cases, but we're just against, in principle, the idea that it would be linked to the discharge. The 1985 Act, when it was introduced, was extremely welcome, in as much as it did away with the idea that a debtor had in every case to earn a discharge, and the concept of automatic discharge was introduced for the first time, and we remain supportive of the notion of an automatic discharge, with provisions in place to deal with those debtors who do not cooperate or comply with statute during the course of their sequestration.
Okay. I might widen this to look at money advice, but I'll take some views on financial education first. If I can go to perhaps the other end of the spectrum and the view of the credit unions, which I think you've welcomed the inclusion of financial education, but have concerns around who should provide that financial education. I wonder if you could maybe expand on that and how you would see a protection being introduced to cover the concerns that you have.
The concern we have is the initial financial advice before an individual would enter an insolvency product. I think we would be keen that there's a separation between who gives that advice and who might actually be the trustee in a trust deed or bankruptcy. We recognise a lot of insolvency practitioners are also money advisors and have those qualifications, but I think we'd be very keen to avoid any danger of a conflict of interest there if there were nudging people towards a particular solution. I think if we can have that satisfaction that it's completely separated there. I think in terms of financial education, we quite enthusiastically welcome the ambition to create a financial health service for Scotland. I think many of the problems of insolvency and over-indebtedness and poor financial decision making, whether it's using higher cost lenders and all the rest of that, comes back to a fundamental poor, poor financial capability that many people have, and I think measures to address that have got to be welcomed. So I think that we absolutely recognise that many people who become insolvent, it's not their own fault, it's an income shock, unforeseen unemployment, unforeseen relationship breakup or other crisis situations. But there are an awful lot of people who have become insolvent because of their lifestyle, because of their spending habits. And I do think we need to bring into that something that will ensure that those, it can't be a case of you need debt relief, your debts disappear and you carry on as before. I think we do need to ensure that there is some behavioural change is encouraged, and we would welcome the provision of that.
I don't want to turn this into Frank McKillop versus Eileen Blackburn, but at the same time, the views that the credit unions are expressing around the separation of who provides the money advice versus who handles the insolvency appears to be diametrically opposed to the submission from Eileen Blackburn, which says that it is imperative that insolvency practitioners are among those who are able to provide that money advice. I wonder if you could address the conflict of interest point that's been raised.
Well, I think in a great many cases, debtors are seeking advice from the voluntary sector in the first instance, those that perhaps are not watching television and looking at the adverts that are on all the time. But if they come first of all through the money advice sector or the voluntary sector, or they go to Step Change or one of those organisations, and they are taken through their budget, and the money advisor at that stage would reach a conclusion about whether they would be suitable for a trust deed or for the debt arrangement scheme or for an informal arrangement, or whether sequestration might be the only option, and perhaps at that stage they might be referred to an insolvency practitioner. But we just felt that as regards to providing money advice in more complex cases, then perhaps an insolvency practitioner would be better qualified in these instances. And my personal view of this in advising debtors, as I do quite often, is to provide them with a full range of their options and to let them know what those options are, and to allow them to make an informed decision, as they can still at the moment, about what would be the most appropriate course of action for them to take, with the full knowledge of all the information that's been given to them.
I note, Mr Hill, in the ICAS submission that you're also sceptical of the benefits of financial education, and also share the view that insolvency practitioners should be among those who can provide money advice. I wonder if you could give your rationale behind these.
On the financial education, we're obviously not against financial education per se. We just very much think it should be earlier than after someone has gone bankrupt. Can I just interrupt you on that? How would you deliver that?
Are you talking about having financial education across the board? Or
I think it should be much earlier. It should be in school.
Because okay, but leaving that aside, because obviously there are a large cohort of people who are no longer at school, who may find themselves in need of insolvency or bankruptcy. Often these are the kind of people who would not come forward to seek that kind of education. So how do you reach those people who may not be able to source that education until such point as they've entered bankruptcy?
That is difficult. There's no easy answer to that. I don't think you would get a vast percentage of the population turn out voluntary to do financial education after they've left school. So I accept that there's it really has to be earlier. It's a long term aim. I accept that. And as I say, we're not against, we're not saying it shouldn't be financial education after bankruptcy. It just seems a bit late. There's questions about who would fund it. There was questions, as was mentioned last week, what would be the sanction if people do it. So there's a few issues with the way it's drafted at the moment, but on its merits, we're not against it as such.
Okay. And then in terms of the practitioners
in terms
providing
of,
money advice?
you know, I get, obviously having spoken about the IB conflict of interest, I can accept it in the face of it. It looks like a conflict of interest. All I could say is that we're under professional requirements to give best advice to the debtor. We have to record that in documentary form, and that is examined, as Maureen says, when we're all regulated at least once every 3 years. And if it's shown that we've not given the best advice and not been down the right route and given inappropriate advice, then we would suffer penalties for that.
Okay. And then turning to Maureen Leslie, the IPA raising concerns about cost effectiveness of financial education. I wonder if you could perhaps give more on that.
Simply, we are aware that in other jurisdictions there are provisions for financial education as a condition of exit from a bankruptcy. I think the United States operates something along those lines. As far as we are aware, and I stress that, as far as we're aware, there's no evidence that it actually has a significant impact, and we have no idea, and I don't think there's any suggestion in the papers that we've read that there's been any costing of that. We have no strong views on it. We simply say that we think if you wish to take that forward, it actually needs a bit more development.
And then obviously you also take the view that there should be reference to insolvency practitioners in terms of the provision of money advice, and one could make the argument that, you know, here we have the 3 representatives of insolvency practitioners all saying we want a piece of the money advice pie. What do you think adds to the mix from having insolvency practitioners able to provide the money advice that is not already there through, for example, money advisors at local authorities or citizens' advice as examples, but other money advisors as well?
Insolvency practitioners, as they're part of their qualification, have to sit an examination in personal insolvency. And that examination is at an extremely high level. It's as high as a degree standard. And as part of that, they have to now study bankruptcy processes, protected trust deed, and they have to be aware of non-formal solutions. And that would include the debt arrangement scheme, debt management plans, the whole range of solutions available to people in financial difficulty. And I think that we also have then, as a professional obligation, the obligation to be independent and objective. So when we're advising someone, both the education and training we have and our professional obligations would put us in a position of being able to explain the wide variety of processes to the debtor, and, as Eileen Blackburn said, allow the debtor to make an informed choice about the particular solution they would wish to choose.
I see Mr Micklett wants to come back. If I could maybe just ask one quick supplementary to Maureen Leslie, and that is, do you recognise, however, that the same conflict of interest arguments that were being raised earlier around AIB, for example, having what could be seen as a conflict role, could arise in this respect, and would you propose any safeguards alongside, if we were to take the decision as a committee to recommend that insolvency practitioners should be among those who should issue money advice, would you recommend any safeguards that ought to be inserted to avoid that conflict of interest from arising?
I can understand the point that the committee is raising about conflict or perception of a conflict of interest, naturally. There's 2 points I would wish to make. That when a director of a limited company is in difficulty, from whom should he seek advice? Would it not be an insolvency practitioner who is able to advise him on the range of options that are available to him? And where else could any company director obtain that level of advice? From his accountant? Accountants, as part of their training, only do a very small part, no more than a couple of weeks on insolvency, and would generally refer on to an insolvency specialist to advise their clients about the options available to them. In principle, there's no difference between the advice given on a corporate level to the advice given in personal cases.
Okay. And Mr Micklett, you wanted to make a point?
The point I wanted to make there on this issue of who gives the advice, and you know, obviously we recognise that insolvency practitioners are qualified. I think it's that separation is important to us. It could be one IP that potentially gave the advice, but we would rather that wasn't the person who was potentially the trustee. And the reason for that, I probably should say that we do absolutely recognise that the vast majority of IPs behave with absolute integrity. But we do know that there are cases that we see where we do have to question the decision that's been made. One example, just to quickly quote, was where the total debt was £7,978 and the debtor was able to pay £195 a month for 3 years. That totalled £7,020. So if that debtor had actually gone into DAS for they could have repaid £195 a month for 3.5 years. It wouldn't even have to be a long DAS. Creditors would have received just over £7,000. Instead, because that was a protected trust deed, creditors shared £1,500 and over £5,000 was claimed by the trustee. So we have a problem there. The question we have is, clearly one of those options, DAS or protected trust deed. Protected trust deed was a better option for the trustee, but it certainly wasn't the better option for creditors. And in that case, given that another 6 months of payments, that person would have been debt-free and would never have been insolvent. They would never be on the register of insolvencies in that regard. It was better for the debtor to do that as well. So we would be uncomfortable because of examples like that we've seen, and we welcome that the bill, as well as the protected trustee regulations, will address, hopefully, some of those situations where DAS should have been used and wasn't. But we would be concerned that things like that do happen. And we would certainly welcome a safeguard to prevent poor examples like that occurring.
In terms of a safeguard, and forgive me, I'm not an expert by any means, but I'm thinking out loud here. Would a safeguard be, for example, that an insolvency practitioner who had issued advice would not then be able to be the practitioner in any case of bankruptcy that arose from that case? A disqualification, if you will, that would prevent the conflict of interest that you've described?
I think from our perspective, yes, either the advice comes from the public sector or the voluntary sector, and then they're passed on to an insolvency practitioner if that's the correct route to take, or if someone has approached an IP or a debt management company in the first instance, there should be a separation. If protected trust deed or bankruptcy is the right option, pass it on to someone else to conduct that.
I've got a couple of, Hans-Ala wants to come in and Mackenzie wants to go. Just before that, on this question of money advice which is to be provided, who's going to pay for it?
Money advice is provided by insolvency practitioners. Most of them offer at least a 1 hour free consultation. In my experience, it's considerably more than 1 hour, and there is no charge for it. So
right.
I absorb that as part of my cost.
Okay, so you're not going to charge, if this bill provides compulsory provision of money advice, that's going to be given free?
Yes, it's given free at the moment, and I see no reason that would ever change.
Okay.
Can I just come in there? Can I just clarify? It's given free for 1 hour. Thereafter, there would be a charge?
We advertise, most practitioners would say that we'll provide 1 hour's free advice. The reality is that it takes considerably longer.
So there would be a
and
charge?
there is no charge, no.
Over that, and obviously people have the choice that they can go down other routes. For instance, step change citizens advice, where it's free regardless for how long.
That's correct. And certainly we would advise them, if they were using a debt arrangement scheme, for example, we would advise them that they can receive the same service free.
Okay, thank you.
Right, Hans-Ala Malik wanted to come in.
Thank you, Chair. In terms of the suggestion in the bill that money advice is going to be mandatory, I just want to retouch on this in terms of particularly first-time applicants, perhaps who've been unaware of the system. I can understand and appreciate and accept the value of money advice, particularly for those either who know the system or have gone through the system. But for the first-time applicant, I feel that mandatory is perhaps a little harsh, and it would cause some members of our community difficulties. And I feel that when a family or an individual is going through a difficult time in their life, the last thing they need is a compulsion to go through other loops and rings. And this is why I'm thinking that perhaps that mandatory should be dropped for first-time applicants. And perhaps we have an advisory note that it is preferable rather than mandatory for first-time applicants. I think that would solve a lot of problems for a lot of people. What's your opinion?
I've certainly a lot of sympathy with that view. I mean, I think that it's a difficult matter because the very situation you've outlined is probably a case where someone really does need the advice, where they're under stress and in all these situations. That's the person that probably does need advice. But personally, I would be against the completely mandatory situation. I think preferable is a good word, and I think they should also then be required to state that they have declined the requirement for money advice before they go ahead, so at least they have thought about the issue. But to make it mandatory, it does seem, there will be some people who will be very annoyed. Some people will be qualified themselves, because you have accountants and lawyers that end up going bankrupt. There shouldn't really be any need for them to have to take advice. They know what's happened. So whilst those may be isolated incidents, I think to make it mandatory for everyone is probably just going a step too far.
The other concern I have is that sometimes people who give money advice are actually strapped for time as well, in the sense that people are overstretched. There are not sufficient people out there who can do that right now, and if the demand is higher than the ability to serve, it means that people would have to unnecessarily wait to get that advice before they could go down that route. And I think that also is unhelpful, because that could be accumulating while you're waiting to see someone for money advice. And I think that also plays into an element where people would perhaps face hardship. And that, once again, I'm concerned about people not being put through that hardship.
I think we all give examples of people that have come to us that have tried to go to the citizens' advice bureaus and not been able to get an appointment for 5 or 6 weeks or whatever. And as Maureen said, for the debt arrangement scheme, for example, you can be put into one of those completely free of charge through a money advisor. But a lot of people choose to pay insolvency firms because they can do it immediately and there's no wait. So there is very much a time issue there.
Thank you.
Mike McKenzie.
Thank you, Convener. I wanted to ask Maureen Leslie, you referred to the American experience with money advice and education was somewhat inconclusive. But I wondered if you were familiar with the work of Professor Warren in America, and would you agree with me that you're not really comparing apples with apples when you try and draw a comparison with the situation in the US?
Mr McKenzie, you've got one over in me. I'm not familiar with that work at all. I think that as far as I was aware, there had been no evaluation of the success of financial education, right, as opposed to pre-appointment money advice. It's, I think, post-bankruptcy, if you like, financial education. But it would seem that I think you're perhaps better qualified than me to actually answer that one.
Well, the point I'm making really is that the situation with regard to bankruptcy in America is really quite a different situation, I think, than we find ourselves in this country. And I would commend Professor Warren's work to you. She's actually now a US Senator, so you'll find her on the internet quite easily. But it's a very interesting comparison, and one that you might find interesting, particularly in the context of this bill. But that's really that was it. But I think the point remains that you're not really comparing apples with apples when you attempt to draw conclusions from American studies. Now, I hope you would either agree with me or perhaps go away and do a bit more reading and maybe come back to the committee with some written evidence.
I will go away and do some more reading. But could I just make one final point in relation to the pre-appointment money advice? And whilst Mr Malik, I think, makes a number of very, very good points, particularly in relation to delay and increase in demand, being party to the discussions, many discussions behind this bill, one of the mischief that this provision in the bill is designed to address is the mischief of people being railroaded into one particular solution. And that's, Ms Blackburn mentioned, people watch television. There's a lot of television advertising. They're advertising one solution. And the concern that the Office of the Accountant in Bankruptcy had was that unless people received independent advice about the range of solutions open to them, they could be pushed into an inappropriate solution, such as Mr McKillop has brought. That was the point, and to that extent, the IPA support the provision of pre-appointment money advice.
Right, move on. John McAlpin?
Yes, it was a point that I wanted to make to Mr McKillop that struck me in his or the Association of Credit Unions written evidence. You're talking about a situation when a person is unable to pay their debts, and suggest that quite often when someone goes into the process of either bankruptcy or trust deed, they don't change their lifestyle to any great extent. And in your written evidence, you say a situation which allows people to write off debts with no tangible impact upon their standard of living, especially in cases where an unaffordable lifestyle led to insolvency, sends out a very dangerous and morally corrosive message, essentially that repaying debt is optional, a situation which is not only bad for creditors, but is socially and economically unsustainable. I'm interested to know how widespread you think that kind of situation is at the moment, and how the bill will address it to improve it.
I think many credit unions have sent us examples of financial statements that they've received in relation to a bankruptcy or a trust deed, where the allowances that that person, that the advisor or the IP in that case has allowed that individual, do seem extraordinary. I think one of the legendary examples in the credit union movement is a case where someone was allowed over £300 a month to drive to work every day. They lived in Rutherglen and they worked in the centre of Glasgow, and on top of that they worked for ScotRail and had free rail travel. So I mean that one's become legendary, as you can imagine it had, and I think there's been a number of cases that have been challenged where as some of our members would tell us, people started eating more as soon as they were insolvent, and their monthly food bill increased. I think perhaps the most extreme example that we've ever seen was a community credit union in Western Bartonshire, where someone took out a loan a fortnight later. They had entered a trust deed without making the first payment on that loan, and the financial statement that came through, their monthly expenditure was £1,000 a month higher than the financial statement they'd filled in to apply for the loan. So these things happen. What we welcome in the bill and in the PTD regulations as well is using a single common financial tool for every debt solution in Scotland. We hope that that will address some of these situations where bespoke financial tools are being used, financial tools which creditors don't understand. So a single financial tool that we did understand and which was used across the board, so that entering bankruptcy or a protected trust deed or debt arrangement scheme was no better a deal for any debtor, that they weren't being attracted to it based on, well, I'll pay less if I go into that one. Likewise, it would remove competition potentially between providers who would say, look, we'll do your trust deed for £100 a month, them over there we'll charge you £120, why don't you stick with us? So I think it would remove any of these perverse incentives around debt relief, and certainly a single financial tool is something that we very much welcome.
I wondered if other members of the panel would care to comment on the examples of excess that you've outlined.
We've been aware of such examples of excess as well. I would really like to think that those are exceptions rather than the rule. I know that many firms already are using standard income and expenditure models similar to those that are used by Step Change and the one that's been developed by the Money Advice Trust. We certainly welcome the use of a single financial statement across the board. We think that would be extremely welcome for most of the reasons that my colleague over here has mentioned. I mean, we do not condone the type of behaviour that you're talking about as a representative body of insolvency practitioners.
I would endorse what Eileen was saying, though. I would also make the point that I don't think we should expect. I think these are obviously extreme examples given, and I'm not denying they've happened, but the vast majority of people are in difficult financial situations before they go into bankruptcy and are still in fairly difficult financial circumstances when they're in it. They don't suddenly get any extra money from anywhere. And I don't think we should be looking at people that go bankrupt having to reduce significantly their standard of living. I think that would be very detrimental indeed. So I think some of the wording could perhaps have been put slightly better in that, from Frank's point of view.
But when you say they shouldn't have to reduce their standard of living, if they are already, you know, enjoying a very luxurious lifestyle, should they not be expected to significantly reduce their standard of living?
Yes, that would be an extreme example. The vast majority of people that go bankrupt are not enjoying in any shape or form a luxurious form of living. You could look at 99.9% of my files, and I can assure you that is not the case. The luxury living is very much the 1 in 1,000 case, and they obviously should, but the vast majority are struggling generally to get by.
Thank you very much.
Okay, I mean, I think Mr McKillop is seeing as some of this directed at your submission. It's probably fair to give you the chance to respond to that. But I noticed in your submission you talk about the common financial tool allowing for luxury items such as satellite televisions and preservations of a heavy smoking habit. I mean, do you actually have evidence that people are currently being allowed to have money to spend on these things?
Yeah, we've got examples of that from credit unions that have been provided, and again, I think what we'd hope for, and again, we certainly don't want anyone to be pushed into hardship. That's certainly not the point that we're making. I think what we do find, you know, there's another example in a credit union in South Lanarkshire that with the danger of people not protecting their social media profiles well enough, quickly Googled someone that had entered a protected trust deed, and they were posting up photos from their holiday, which they'd gone on with the loan that they'd just written off to the credit union. So there are situations like that. You know, I absolutely agree with Mr Hill. It's a minority of cases, but they do happen, and I think, you know, the whole point of legislation and regulations is to stop the possibility of abuses like this occurring, and that's certainly our perspective on it. So we don't want people to be forced into hardship, of course we don't. But there are situations where people are enjoying, you know, as some credit union managers will say, that the people in debt have got a better lifestyle than they have, and the financial statements that have been presented in the past allow them to maintain that. I think it makes sense. You know, if you've got yourself into a situation where you cannot pay your debts as they fall due, it makes sense that, you know, to pay something back to creditors. And again, I come back to the point, creditors expect something back when someone becomes insolvent. Of course, there are cases when nothing can be recovered, we recognise that. But cases where something can be recovered, we expect something back. And to pay something back to creditors would generally involve cutting back on something you're spending elsewhere. And many people's situations, they are able to do that, and we'd like them to be given a nudge towards that, to perhaps cut down on whether it's smoking or their TV choices or other leisure choices, so that they can give some sort of payment to creditors to recognise that, look, we owe you an awful lot of money and we're not going to pay it all, but we'll pay you something, and we will cut back on our own lifestyle to accommodate that.
Thank you. Alison, you want to come in?
It's just kind of on that issue. I think that the credit unions strongly are putting over the message that we mustn't accept that debt is something to be taken lightly, that we should take our responsibilities very seriously. There doesn't seem to be a great deal of concern about extending the repayment period, although they're obviously, Mr Hill, you're suggesting that most people who are in debt are suffering really badly, that times are really difficult for them. Just wondering if there's any concerns over the period. You obviously feel, Mr McKillop, that extending the period sends out a strong message that you owe this money and we will expect you to pay it for as long as possible. But there are obviously concerns on the other side that it might be more expensive to continue to pursue the debt for longer as well.
One thing you have to remember is that when you do go into a bankruptcy, you then no longer have to make the payments you're making to your creditors. So you can afford to make a contribution without having to reduce your day-to-day expenditure. You might have been paying £200 or £300 on your loans up till then, and you no longer have to make that once you go bankrupt. So in theory, you have £200 extra a month. Now, obviously, you don't have £200 because you couldn't afford what you were paying before, but you can afford to pay something. And we would certainly support the proposal that someone who can afford to pay should pay, and that, as Frank says, that creditors are due to get something back where possible. If someone can't afford a contribution, then they won't make one under the financial tool. But if they can afford to pay, they should pay. And the question of how long they pay is a complicated one. Obviously, the bill suggests it's extended to 4 years. but that doesn't seem too unreasonable. It's currently 3 in a bankruptcy. 4 is not a major change in it. Perhaps balances more towards the creditor's view that people who can pay should pay, and creditors will get slightly more back.
Thank you.
Okay. Bring in, sorry, Dennis.
That was a different point also.
Right, okay, well, Margaret McDougall, come in and I'll come back to you.
It's on a different point. One of the main options or changes in the bill is the change from LILA to the MAP. And I just wondered, given that it's a 6-month discharge with the MAP, and that, when we've heard evidence that that is inconsistent with the other options that are available, I just wondered what Eileen Blackburn, for example, felt quite strongly about that in your submission. So if you could tell me what you think.
And a 6-month discharge period is just simply too short, and we don't see why in a MAP situation it should be any different from a normal bankruptcy. 6 months seems an infeasibly short space of time. I think during the consultations that have gone before, we felt at the time, in fact, that 12 months was too short a discharge period in many cases. However, that's what we have now, but we see no reason why under the MAP system it should be just 6 months.
I would simply add, I think there's a slight bit of confusion about the purpose of the MAP and the LILA. LILA, when it was brought in, was a route that people could go into bankruptcy to alleviate the situation where it was difficult to become bankrupt, and there wasn't sufficient routes to become bankrupt. When the certificate for sequestration came in, which meant that any money advisor can sign a certificate allowing someone to go bankrupt, there really wasn't any need for LILA. There really isn't any need for people who go bankrupt to be treated differently. If they can't afford a contribution, they don't pay one. So there's no, my personal view is there's no need for MAP at all. If you go into a bankruptcy and you can't afford to pay, you don't pay. You don't need to be in a special one to be doing that. It just complicates the issue, and I think has led to some confusion as to why it's there.
I just wonder what Frank McKillop's view is on that.
We generally don't take too much of a position on these situations. You know, when there's a situation where nothing can realistically be recovered for the creditors, and then we've always been fairly, reasonably relaxed about how that's approached under the law.
So the change from LILA to MAP is, in your opinion, not required, or just shouldn't be there as an option? Or?
Well, I think, as David said, it was that LILA was first introduced to allow people who were suffering extreme distress and had no route into bankruptcy. Previously, it was introduced to allow those people with very low incomes and no or virtually no assets to have access to bankruptcy. But as David pointed out, there's now the certificate of sequestration route, which really opens the door for anyone that needs that type of debt relief. We've not made a particular point about whether we feel the MAP is necessary or not. However, I think at committee, when we were here last week, there did seem to be a bit of confusion even within the membership of the committee about exactly what the purpose of it was.
Thank you.
I mean, just going back, Mr. Hilder, what you were saying about MAP, is the point of MAP not that the administration costs are less?
Yes, I mean, that is the point, but it's only less because there's less work done. Creditors receive virtually no information at all. They get one letter currently saying you're getting nothing, close your file, and we won't write to you again, and that's how costs are saved. Now, that might be deemed to be the right way, but part of the point I'm making is that a bigger issue would be those debtors in those circumstances can't afford the £200 fee or even the £100 fee that might be proposed for the MAP, and it would be perhaps better using any savings to allow those people not to have to pay a fee. Because I think the MAP generally just leads to confusion, and the detail of it, where you're discharged after 6 months but have restrictions for 12 months, is even more confusing. So there's a general sort of difficulty with it.
You said the alternative would be, is it a certificate of sequestration?
That's simply the route into bankruptcy. It used to be actually quite difficult for debtors to petition for their own sequestration. They had to have a charge for payment or something similar to establish that they were in fact apparently insolvent, and that was recognised as a big issue. I think anecdotally we were hearing stories last week still about money advisors who have got, you know, drawers full of cases where people are unable to apply for bankruptcy because they don't have the requisite £200. Well, in the old days, it didn't matter how much they had available, they had no route into bankruptcy. So for the very poor members of the community who were really, really struggling and could see no way out, the Leela was introduced for those people.
But you said that you debate not having the map at all, or it might have been David Hill. So you just get this sequestration of, you know, certificate of sequestration. So how much does that cost, and how does...
Itself doesn't cost anything, but there's still the application fee. As Eileen said, the certificate is just a route, one of the routes that qualifies you to become bankrupt. And it was brought in, when it was brought in, that really took up, the Leela route was brought in because you couldn't become bankrupt, but then the certificate was brought in later, so you didn't need to qualify for the Leela rules to become bankrupt. See, it sounds confusing, and it is confusing, and I think that's part of my point.
What I'm trying to get to is how much would it cost you then to get the qualification, to get the certificate?
Doesn't cost anything to get the certificate. It still costs you £200 to apply for your bankruptcy.
Right.
The certificate is an instrument which is provided by a qualified money advisor. So someone signs a form to say this person is insolvent, and that allows them then to apply for their own bankruptcy once they have this certificate.
Thank you.
Okay. Dennis Roberts?
Yeah, maybe a question to Ms Blackburn. The bill is proposing a period, a moratorium period. Do you support that?
We felt it might just be a bit confusing. I think we were supportive of the idea that if we're looking for commonality across the various processes, then a 6-week moratorium period might be appropriate. We just thought it was going to be a bit confusing, and we're wondering how it would interact with the provisions of Section 37 of the Bankruptcy Act, which deals with diligence. It's perhaps a somewhat technical point.
Just a bit. Yeah, I mean, does anyone have a particular view? I mean, I think the moratorium period does give that bit of breathing space, does it not?
Sorry, yes, I think it does. I mean, we wouldn't be against it at all. I mean, it might not be used in a lot of cases, but if it helps some people, then yeah, I don't think we would be against it in any way.
The IPA is supportive of that.
Good. Excellent. Thank you. Mike Mackenzie.
Yes, thanks, Convener. I just wanted to briefly recap. Mr McCallum was saying quite strongly, I think, that he was in favour of the Common Financial Tool and Statement. Are the other committee members quite happy and in agreement with that being brought into use?
Yes, absolutely.
Right, thank you, that's useful.
Okay, if there are no further questions, I think we can call it a day at that. Thank you very much for coming in to provide the committee with evidence, and we will have a 5-minute suspension until I change over. Thank you. Right, if we can reconvene, I'd like to welcome our second panel of witnesses. We have, starting on my left, Martin Pringent, who's Head of Insolvency Management at TDX Group Limited, Mike Norris, Executive Director of MAX Recovery Limited, Donald McKinnon, who's partner with Wiley and Bissett, and Alison Anderson, Insolvency Director of Armstrong Watson. Thank you for joining us this morning. Some of you might have heard some of the previous sessions, so I think we'll probably have some similar questions that will come up. I would just remind members that they can keep their questions short and to the point, and given we've quite a large panel, if they can direct their questions to a particular individual, that would be helpful. And if you're on the panel and would like to respond to a question that somebody else has answered, please just catch my eye and I'll bring you in as time allows and let you have your say. I wonder if I could just start off asking a question we put to the previous panel about this question of the accountant in bankruptcy reviewing her own decisions, and whether that's an appropriate change to make in the bill that's before us. There are some concerns that there might be a conflict of interest in this, and some previous panelists said it would be better to leave this to the courts as it currently stands. I know, I think it was Armstrong Watson in your submission, Alison Anderson, you said something about this. Would you like to start and tell us what your concerns are about this?
Yes, we do have a concern in respect of the conflicting responsibilities of the accountant in bankruptcy as policy advisors putting new policy in place and then being appointed trustee in cases whereby making decisions regarding those cases and resultantly dealing with management and debt relief services as well. There is a conflict of interest. It's in our professional life, we are not allowed to have conflicting interests in what we do, and for they to be involved with advisor, supervisor, taking fees in respect of cases whereby they have initially dealt with the policy of those cases all through to the discharge procedure, we find there is a conflict of interest there.
Okay. Somebody else on the panel agree or disagree with that? You, Mr. McKinnon?
Happy to agree with Alison.
Agree. Mr. Norris?
Yeah, I mean, first of all, if I could just give my background, prior to working for Max Recovery, I worked for 23 years in the AIB's equivalent in England and Wales. So I am slightly biased, but I would actually agree with what Mr. Robertson said in the first session, that there are actually people in the civil service who can make these decisions. I don't think that is an issue. And I actually think the whole conflicts issue is a little bit of a red herring. You know, we can see conflicts everywhere, and in fact, the key issue is how do we identify those conflicts and how do we deal with those conflicts for me. I'd say I've got no real issue with the AIB acting in this regard. Two provisos: they need to be properly resourced to carry out this function, which then raises another question about how that function would be funded. And the second point is there needs to be adequate checks and balances to make sure that anything they do is done in the correct manner. I think there's a bit more work to be done in that area around checks and balances. But equally, I've actually got no issue with IPs undertaking advice and the case, as long as, again, there are proper checks and balances, and that must fall to their regulator to do. That actually seems to me to be quite an efficient way of carrying on, where you've got someone with knowledge of the case taking over that case straight away.
Okay. Mr. Pridgeon?
I tend to agree as well. I certainly acknowledge the concerns of a conflict. I think, to Mike's point, there are ways to try and mitigate that. And I think from a courteous perspective, you are normally looking to the regulator to provide that sort of unbiased, balanced position. And I would question whether, if the AIB actually was trustee in some of these cases, whether that would be provided.
Okay, I mean, we heard a suggestion from the previous panel that there might be some independent review body established. Was that something you would favour, or do you think that's necessary? Yes.
Absolutely favour.
Yeah, I'm sort of agnostic about it. I can't see it doing any harm, but I'm not convinced it's absolutely necessary, providing maybe there's a route into the court for appeals. I don't know. So as long as there's something, I don't quite know what that something is, but maybe a panel is fine.
Okay. Okay. Right. Okay. I'll bring in Mike McKenzie.
Yeah, and it's for Alison Anderson. I just wondered if, you know, do AIB have do they have a history of making bad decisions? I just wondered if that's what's risen to your concern.
I think this bill doesn't identify how we can come round, to mitigate the issues that we consider there is a conflict with. I think this bill moves further into the depth of potentially a conflict issue. However, as Mike indicates, there doesn't, the mitigation side, the bill doesn't deal with how we're going to resolve those issues.
Sure, but I mean, and Mr. Norris did say there are conflicts of interests, and we're having a discussion, generally about, there are, this whole area seems to have a number of potential conflicts of interest, but, I just wondered if there's anything, if it's purely a theoretical concern about conflicts of interest should never be condoned under any circumstances, even the merest hint of one, or whether you've got some substance behind that to suggest that AIB actually are not very good at taking these kind of decisions. A yes or no answer would be fine.
I suspect it's perhaps maybe the culture that we've grown up with within the profession and the sort of the ethical guidelines and rules that we've worked with for the last 20 odd years.
Okay, thank you. Yeah, and just my second question then is, you think that courts sometimes get it wrong? They occasionally make mistakes?
I think there's different sheriffs make different decisions, and that is an issue that does happen and does give us under accounting bankruptcy some issues to deal with in respect of one sheriff making a decision on something and another sheriff making another decision.
Right, okay, but so courts sometimes make mistakes. There's a perception of a conflict of interest with AIB. There's not really a clear and easy answer here, perhaps?
I don't think there is a clear and easy answer.
Thank you.
Okay, Hans Allen Malik.
Yeah, thank you, Chair, and good morning. Thank you for joining us. Mike made a comment that he had a conflict of interest, or he comes from that industry, and he's also suggesting that perhaps AIB can deal with issues. I'm sure they can as well, but I think when there's a conflict of interest where finance are involved, money is involved, I think it's prudent not to then go down that route for all parties concerned, not just the industry itself, but also the applicant and the client. And I think you're quite right in terms of historic principles. In terms of ethics, we in the UK are very proud of having very clear ethical stance. We tend to be transparent, and we tend to be very clear in what we do in our dealings, particularly when it comes to money and finance resource. And I think, therefore, it's important that we have an independent body that deals with it rather than the service provider then goes back and makes their own judgment and charges for it as well. So I think that there is a very serious issue here in terms of that ethical stand. And I'm not suggesting that the IBS is not capable of making decisions, but then to suggest courts make mistakes as well, I mean, we're just going down a slippery slope in the blame game. I think what we need to do is try to make sure that what we do is have a system in place which is fair, absolutely transparent, no conflict of interest for anybody, and therefore no one can be accused of anything in the future. And I think that's important. And also I think there's no harm if we're trying to save courts time, which then setting up another independent arbitrary organisation is probably a better solution. Yeah, well, I mean, the question that I want to make is, how can you guarantee absolute transparency when you're making a judgment on something that you've already delivered? That's to Mike, first of all. The one with the experience.
I don't think you can absolutely guarantee it. I honestly don't think you can. As like I said, I've really got no issue with anything you said there around fairness, transparency. I think that's absolutely correct. And the point I made is, I don't really, as a creditor, I don't really care who does it, who's the independent reviewer or the reviewer. as long as it's done fairly transparently, obviously in a cost-effective way as well, because ultimately the cost of these sorts of things will fall down on the creditors, no matter how it tends to pan out. And to say maybe the independent review body is the way to go. I can honestly say I've not really given it any thought about how it should be done. It's just that if the Scottish Parliament decided that it was going to be done internally at the AIB, then that intrinsically would not cause me a problem as long as I was satisfied that were proper checks and balances within it.
Just to recap, and Martin, I mean, I'm coming to you now as well. I mean, you've heard the answer from Mike in terms of what his position is on this issue. Would you agree with him?
I think from my point of view, I think if you had the blank piece of paper in front of you and you just sort of drew out what this would need to look like, you would probably draw, you know, a separate regulator, completely separate to the people that would provide the services, so that you do get something that's completely unbiased and balanced. We're not quite there, obviously, because this thing is already in process and it's quite a complex process that we live in. But I would like to sort of try and see us move to that kind of blank piece of paper approach and have a separate regulator versus separate service provider.
That's very helpful. Thank you very much. Yes.
Thank you. Dennis Ross.
Thank you, Convener. I'll probably direct this to Mr McKinnon first, please. I said earlier that I suspect that AIB do have people maybe with the appropriate knowledge and maybe professional skills to maybe take things forward the way it's been suggested. At the moment, we're actually looking at the general principles of the bill. We're not actually, delving into the absolute detail at the moment. Would you accept that AIB, given what they've said, would be able to resource and provide the transparency and fairness that Mr Malek's actually referring to at the end of the day, when we move on through the different stages of the bill? Because at the moment we're looking at general principles, and AIB are giving us an assurance that they will be, I think the word they used initially was independent, and perhaps they can't be independent, but they do believe that they are the right people to do this in terms of the reviews. Mr McKinnon.
Largely independence is largely based on perception, and I think at the end of the day, if the perception suggests otherwise, that could be a conflict of interest. But in terms
of perception, though, Mr McKinnon?
I think from a creditor's perspective, there may or may not be, but if there is a public perception that there's no way you can alleviate that. I think the skill set does exist, but having practically worked with the accountant in bankruptcy, the skill set generally only applies for a period of time because the skill set moves on to another area within government. As it stands at the moment, my belief is the accountant in bankruptcy does not have a qualified insolvency practitioner. They had one qualified and has moved on. In practice, I've worked with the accountant in bankruptcy for a number of years, and in recent terms under contract 1 and contract 2 of a service provision, and it seems to me when you get to a certain level within the accountant in bankruptcy, for whatever reason of career progression, the individual moves on and we have to go through the cycle again.
So in evidence last week, AIB were sort of giving us the sort of assurances that, they were going to resource this, they were moving towards it, they were going to ensure that the checks and balances were there.
That may be the case. Accept that? That may be the case going forward, but I can only act on statistical information and practical, what I've dealt with over the last 6 years.
So you don't agree with the general principle? That's what I'm trying to get at.
If they're able to deliver, fine. But as I say,
so you do agree with the general principle then?
If they can deliver it.
Okay, well, that's fine. Thank you. Anyone else?
Anyone to add to that? No?
No? Fine.
Okay, on this same point, Alison.
I was just around the conflict of interest. I think a witness last week suggested that if we were discussing whether or not there was a conflict of interest, that there was already a conflict of interest. Is that a view you share? And, I believe it seems to be the case that the public are always very unhappy when they see an organisation tasked with investigating itself. It doesn't have the separation that is required. So do you agree that regardless of how many firewalls and whether this is set up with the best of intentions, and even if it does work entirely independently and smoothly and as you would wish, it just will never ever have the trust that it needs to have.
Well, I guess from a conflict point of view, in practice, if there is a conflict, there always is the opportunity for the insolvency practitioner to resign and be replaced by another. I'm not sure how that would work in practice going forward.
Do you have a comment?
So yes, I do. I agree. There's always a problem with public perception. The view I gave was a creditor's perception whose industry works within the insolvency industry and works closely with the AIB. So we're in a position of having, excuse me, having some knowledge. So for me, that perception isn't there.
Mm-hmm.
But I absolutely agree that the wider public perception will be one of that can't be right.
Mm-hmm. Okay, thank you.
Okay. Okay, thank you. Right, I think we're going to move on to a different subject and bring in Mark MacDonald.
Thank you, Convener. You may have overheard the discussion around money advice and financial education in the first session, and I want to cover that topic again because, again, I see before me in the written evidence a range of views represented on this. If we could look at financial education first, I note that there is question raised in Mike Norris's submission around the effectiveness of financial education. Now, I'll freely admit that I'm not as well read as my colleague Mike McKenzie is on the US example, but I note that you make reference to the US example in a number of papers in relation to that. I'm not sure whether the one Mike McKenzie referred to was one of the ones that you've read, but perhaps you could explain your rationale on that, and also maybe address the point that my colleague made earlier, which is that to take the example of the US scenario and supplant it to the Scottish example might not be the most helpful of comparisons in terms of comparing like with like.
Just on that very last point first, if I may, the apples and apples. I mean, again, having been in the policy side of government for about 8 years in previous life, using other regimes' experiences is commonplace and sensible, in my view. You have to be very careful because there's about sort of dropping what they do in the US or anywhere else on top of any other nation state, because there will be local reasons why that may not work in that state. So I think you've got to be very careful, but I don't necessarily agree that you can't make a valid comparison. You just need to recognise the differences. I do know the work of Elizabeth Warren. She was actually the co-debtor advocate with Karen Gross, who I mentioned in my submission, on the board that looked at the would have been the BAPCA Act, which has now been in 7 or 8 years ago. Karen Gross is now a president of a community college. Her career has not progressed to the same extent as Liz Warren, who, of course, in between time was also the initial head of the Consumer Financial Protection Bureau. So absolutely agree that Liz Warren speaks a lot of sense. My point is really, and actually, if I could just isolate first, I have no problem with advice going into insolvency. I think that's absolutely right that people should have to seek proper advice prior to making what is a fundamentally life-changing decision in some instances. So I've got no problem with pre-insolvency advice. My issue is with post-insolvency advice, and specifically with tying it to discharge and making it mandatory. I think it should be debtor choice, and I think it was rehearsed earlier on that not everyone necessarily needs advice. People do fail for valid reasons, and they may not benefit from that advice. I think the reason I used the US experience is because, and if it's okay, I'll just give you sort of a minute or so about what they did in the US, because it might be useful information. They introduced a system whereby you had to get advice coming in and you had to get advice coming out of bankruptcy. Now, the way they did it was they set in place a maximum fee chargeable, and that advice had to be provided by a trustee, a bankruptcy trustee. It was $50 each, maximum advice, and with respect to the IPs, if you tell an IP that they can charge up to $50, they will charge $50, in my experience. And that's what happened, and eventually it became a de facto cost in the bankruptcy. And the problem is, for $50, you really don't get much advice. And what happened was most US trustees would have a computer terminal in the corner of their office. The debtor would do what the debtor has to do, and the final thing they did was sit at a desk in front of that computer terminal, going through an online course which was not supervised, literally click the buttons, get a certificate, and that's it, done. Now, to my way of thinking, that is completely and utterly pointless. And in fact, if you talk to US trustees, they would say it's completely, utterly pointless. So that's why and that's the position that Karen Grosser came in on when she was on the committee. She went into those committee wholeheartedly supporting mandatory advice, came out of the process wholeheartedly against it because of what was being put in place. So I absolutely accept that Liz Warren's mind wasn't accepted, and in principle, it wasn't changed, sorry, and in principle, you know, she stuck to her principles, I guess, and maintained that it's a good thing. So I think the problem is, if it's going to be done, it's got to be done well, and to do it well is not cheap. And that's, again, as a creditor, that's my concern, is who's going to be doing it? And my understanding it's going to be done out in the money advice sector. Well, that's fine, but someone's got to pay for that advice. And that's a real concern in this day and age. Where's that money going to come from? Because if it doesn't come from the Scottish Government, it's likely to come out of estates, which means it's coming out of creditors' pockets. And for something where I don't think there's a body of evidence out there that wholeheartedly says it's a good thing and it works, then, you know, I think that's a bit of a risk.
Can I follow? I just want to follow a couple of supplementaries.
Mark, follow the line of question. I'll bring you Chick in afterwards.
Yeah. I hear what you're saying there, and I take the point that you make. And I think the question I would have is whether you would consider that the principle is flawed, or whether it is that that what you have here is a good principle in terms of the requirement for financial education, and it's about how that principle is then executed in practice that is key, and obviously that would be something to be followed through in post-legislative guidance. So would your contention be that you're not opposing the concept of financial education? And I take the point about debtor choice, of course. The flip side to that is that very often the debtors who require it the most are the debtors who don't choose or would not choose financial education. But would it be your point that the principle in and of itself is not flawed, it is how it is executed in practice that is going to be the acid test on this?
I think my point is the principle of financial education I absolutely agree with. The principle of mandatory financial education I do not agree with. I think it is a waste of resource, and I think we have to be realistic that if it's going to be done, it needs to be paid for, and to have people going through that incurring costs when they don't need to is a waste of money, to be blunt, and probably a waste of their time. Debtor choice was probably it's a bit of a flip phrase to use, because you're absolutely right. If you give a debtor a choice, he's going to say, do you know what, I don't need it, I'm not going to go. Some sort of targeted referral would be better, in my view. So someone's got to take a view, and that may be it may be the trustee, it may be whoever, but someone should be looking at the facts of the case and say, actually, you know, why did you take out that ridiculous, I don't know if we've got any payday lenders in the room, that ridiculously expensive payday loan when you could have gone to a high street bank? Whatever the reason is, someone's looked at the fact of the case and said there's a need for financial education for that individual. That's fine, I've got no problem with that. But to say that everyone going through a system should have that, I think it's almost to be blunt, it's almost a lazy way of approaching it, in my view.
Okay.
Yeah, I think just probably to echo some of Mike's words there as well. I don't have any knowledge of the American system, but the computer in the corner of the room sounds quite interesting. I think if you look at the outcome that you're trying to achieve with this, you're looking at trying to rehabilitate, and you're looking at trying to rehabilitate the debtor so they become this sort of financially functioning individual again, to the benefit of everybody. And I think if you ask the debtor, that's what they would want. If you ask the creditor, that's what the creditor would actually want as well, because you know the markets are competitive out there. I think there's an important component in all of this, which is actually the solution itself. And I do agree that education coming into the solution is quite important. But if you have the right solution that the debtor is working to over, you know, sort of 4 years or whatever that time period might be, that in itself is actually giving quite a large amount of education to the debtor about how to manage their finances. So I think there is actually quite a good piece there as well about the solution itself actually should be rehabilitating the consumer.
obviously the concept of money advice and financial education, there's the prior money advice and there's the financial education. In terms of the money advice, we heard evidence around the ability of insolvency practitioners to dispense money advice, and we heard the Association of Credit Unions apply some caution to that notion. I guess I would just wonder what the panel's view is on, firstly, whether IP should be involved in the list of organisations who can provide money advice. Secondly, what distinguishes them from the other organisations who are currently delivering money advice, and thirdly, if we are going to recommend as a committee that insolvency practitioners should be included in those who can dispense money advice, should we include a safeguard similar to that which the credit union suggested, that any insolvency practitioner who is giving advice would be prevented from handling the insolvency or bankruptcy of the individual whom they are advising? So I could get the views of the panel on those points. Perhaps start with Alison Anderson and work along.
Really, I agree that a money advisor should include an insolvency practitioner on the list. We are highly regulated and highly qualified and experienced to give that money advice in the sector. You know, that is the first point, is that we should be on that list.
Okay.
I think almost to mirror what Alice is saying, yeah, absolutely agree, we should be on that list. In terms of we're probably the most heavily regulated money advisors out there. We're subject to self-conformity to whatever period or organisation you choose to be licensed through. But perhaps if I can just mention a little bit on, again, the financial education, if possible. Absolutely no doubt that financial education should be at some point, but certainly not a point of discharge. And if there is an appetite and a budget to be able to deliver this sort of education and training, it should go back further down the food chain before the debts are incurred. I've been worked very closely with accounting and bankruptcy under a contract 1 and 2. I've called off in excess of 4,000 cases in the last 4 years, and having done a very rough analysis, probably about 50 of those cases relate to repeat offenders. So I just asked the question whether education would help the other 3,950 people.
Okay. I think they should be in the list of organisations. What distinguishes them? I don't mean to be flip about it, but not a lot really. I mean, in terms of money advice, I think there are some money advisors out there who are very, very good at identifying the right option for the individual and signposting them in the right way. But equally, I think there are some very good IPs out there who can do that as well as the money advisors. And there is a level of regulation, as already been referred to, that sits above insolvency practitioners, which, to be frank, I'd like to see go further and actually really test the quality of the advice decision, because I think that would put the IPs in an even stronger position if the regulators weren't just looking at the progress of a case, but actually looking at how the debtor went into that case. It's very difficult because it's very subjective and benefit of hindsight, all those sorts of things, but I'd like to see some effort in there. In terms of safeguards, again, it comes back to proper regulation. I think that people need to be aware of, the regulators need to be aware of what's going on. I always get concerned, actually, if you say they can't take the case, whether or not just cosy arrangements will arise. So, okay, I won't take the case, but Fred down the road will take the case, and I know that I'll get his cases. So there's still scope for sort of abuses. Not that I think that would be widespread, if I'm honest. But also, I just wonder whether there's something else that could be done in the 6-week moratorium period as well. So I know I'm not quite sure how that would work entering the moratorium and whether you've already taken the advice and acted on it on that point, but whether you could build some sort of cooling off period that if the advice is go into sequestration or bankruptcy with me, then you have to have a cooling off period before you actually do it, so you can go away and reflect upon it, go and talk to a CAB if necessary, and do that. So that's my view.
So essentially, the potential to seek a second opinion.
Yep.
If you will.
Yep.
Okay. And Mr. Pritchard.
So I suppose so. My organisation sits between advisors and debt solution providers and creditors. So we have seen quite a lot of cases come through ourselves from a wide variety of providers, and that would include on the debt management side as well. So with the charity sector and the free advice sector, and also insolvency practitioners as well. And you know, we see examples of great compliance and great advice to the consumer from all of those different sectors, but we also see exactly the same failures with some cases as well. So I think it's not necessarily a particular group that's any better than the other. I'm fairly agnostic, I think, and I think to Alison's point, or also Donald's, I think the IPs are very well regulated, very heavily regulated as well in a lot of fashions. So why that wouldn't then sort of transfer also to be confident and comfortable in the proposals that are put forward. I think probably should be. I don't think there'd be any worse or maybe better than anybody else out there.
Yeah, if I may, just following on Mark MacDonald's point, and really to seek clarification. In the previous session, we were told that money advice was given by IPs for an hour and there would be no charge. And I think I heard Mr. Norris say that such advice would take a fair amount of time. Is it charged for? Do you charge for money advice?
I am not an IP.
Well,
so I wouldn't.
From,
I would
from
not
your
know.
knowledge.
I'm probably the wrong person to ask. I don't think I mentioned anything about IPs for an hour. They did. They certainly mentioned it in the previous session.
It takes as long as it takes.
Yeah.
Quite honestly, I think it's to put yes.
Yes.
Okay, thank you.
Mike was on the same point.
Well, similar. We heard earlier on from the Association of British Credit Unions, who, in their written evidence, and this is something I have some constituency or regional experience from, that there are IPs who are known on the street, as it were, to give good deals in terms of affording people with debt problems the ability to continue with a high-flying lifestyle, as it were, after having gone through one of the insolvency or debt advice processes. Are you aware of that? I mean, surely in terms of what you've been suggesting in regulation of the industry, that wouldn't be possible.
Involved in a couple of profile cases, and I think there's always again public perception, because the creditors are quite happy to suggest that somebody may be driving a particular vehicle, but in reality that vehicle 9 times out may not be owned by that individual. It could be owned by a third party, a finance, or whatever, but if that person is seen to be driving, it's an automatic assumption it's that person's vehicle. 9 times out of 10 that's simply not the case.
So are you suggesting that the credit unions are entirely wrong here?
I'm not suggesting entirely, but it comes back down to perception again. Every case is judged in its own merit, treated in its own merits. Solvency practitioners are heavily regulated. Most firms are internally regulated, externally regulated. Having been worked in the profession for over 20 years, I've never seen so much regulation in my life. So.
Okay, and do you think it's perhaps because they're over-regulated that there seems to be a prevailing situation where IPs, companies or partnerships or whatever, seem to be constantly breaking up and being taken over by others, bought over by others, you know, so much so that when you try and follow any particular case, it's sometimes almost impossible, because the people dealing with it, the company's been bought over several times, the people dealing with it have changed and so on. Do you think that's because you're so heavily regulated that you don't seem to be able to survive as businesses for very long?
I'm unaware of, to be honest, lots of firms breaking up and moving on.
I think it's just the kind of world we live in that that happens, but I don't really see the relevance to this for that purpose. But
most often the cases would transfer within the practitioner as well.
Yeah. It just seems that there's a high degree of this happening, and that perhaps that makes it actually difficult to regulate, because
The cases would transfer the regulation would transfer it. Whoever you choose to sort of practice under the banner of is almost irrelevant.
The IP is regulated.
Yeah, but then IP is leaving, they're no longer dealing with that case, somebody else has taken over, then they've left, and, you know, that seems to be quite rife within this kind of sector.
I'm not sure quite how relevant this is to the bill before us, Mr McKenzie.
We're talking about, convener, you know, perceptions quite a lot, you know, and public perceptions, and it's difficult, I think, to sometimes separate, as you quite rightly say, anecdotal evidence from widespread practice, and that's the area I'm trying to explore. What I'm suggesting is that all areas that relate to this difficult business are subject to these same perceptions, and that nobody is particularly seen as absolutely reliable.
Yeah, can I just address that question from a creditor's perspective? Because we're a bulk creditor. We have thousands of trustee cases, and we look at clearly. I mean, money coming back to us is quite important to us. So we do want to see this, you know, this happening. And I think this idea that there are a large number of debtors out there playing the system, I think, is a bit of a fallacy from our perspective. We just don't see it, and I'd be interested to hear from Martin's view is on this. There are some. There absolutely are some. But is it a majority? Is it a significant minority? I would say no. I honestly believe that the vast majority of the debtors are in the position they're in because of no fault of their own, and the vast majority of cases, IPs generally do an okay job in terms of coming at a reasonable level of repayment for debtors. Could be higher, but I'm a creditor, I would always say.
Thank you. That's very helpful. Thanks.
Okay, Margaret McDougall.
Thank you, convener, and good morning. It was really on the money advice and the resources that are available at the moment. I mean, we've heard evidence that money advisors, particularly in the voluntary sector, and, you know, local authority money advisors are really being stretched at the moment, and that's not likely to get any better. So from that point of view then, would you say that it would be necessary then for IPs to be available to give money advice, because the voluntary sector is under so much pressure, and, you know, there's long waiting lists. If you phone up Citizens Advice, you have to wait for an appointment. If you know, go to the council for money advice, it's the same. You know, sometimes you can't even get through on the phone. So would you say that because of the demand for money advice, that therefore IPs should be giving money advice? Sorry, Donald. Yeah.
Just in a practical world, again, from a commercial point of view, the solitary practitioner is generally available 7 days a week and can visit the individuals in their home most anywhere. I think having worked and being a chairperson of Citizens Advice Bureau, I see from both sides of the table as well. Generally, they have different sort of protocols where they would book 2 people in the morning and 2 people in the afternoon, whereas a similar commercial practice would be able to see more people. Not that they're actually churning them, it's just to have perhaps more staff and a different attitude, as a commercial attitude, to seeing these individuals.
There's no allowance for resources within the bill, so the sort of implication is that money advice would be free. So would that be the case if it was independent?
Yes, I mean, yes. The practitioners should be on the list because of everything that's been said before. And as Donald said, commercial businesses like Armstrong Watson, Wiley Bissett, you know, we do see a lot of people for advice, and that advice is free. They come in, make an appointment, and it takes as long as it takes, and that advice is free.
All right, so it wouldn't just be an hour, you would be able to go back
it would
a week
be how
later
long
and see you again and
it'd
see.
be how long it takes. You have to bear in mind all the circumstances of that person coming into our office, that huge amount of effort that is taken for them to actually realise they have a problem. And as you say, they can't get on through the phone to various bodies, so therefore they've almost taken the plunge to make that call, and they've been let down. You know, we pick up the call and we run with their case in respect of giving them advice, hearing their story, and very often hearing their story actually makes it easier for them to see the wood for the trees.
And then on the further education then, we've heard from earlier evidence that that should be actually part of your education at school. And what do you think of that?
I think that's an excellent idea to start it very early at school. I would have to agree with Donald in respect of out of the cases that he's done, there's been 50. I've administered, approximately 2,000 cases since 2004, and I have to say that, we are talking in a really small percentage of cases whereby any financial education would actually help, these individuals. Is minor.
Right, so, for example, Mike Norris, could you perhaps elaborate on, you've mentioned the computer system that was in the US, but how would that be provided in Scotland if we went ahead with it?
Well, I think, it's very useful. I wasn't aware of those sort of proportions of people who suggest as being needy of financial education. But actually, I'd rather, if there was going to be money spent on it on estates, then I'd rather see those 50 people get a real in-depth financial education course in some way, which might be one-to-one, face-to-face, it might be computer, it might be remote learning. Because again, that's the other thing that, maybe Scotland's got its own peculiar issues with this, with people living on remote islands and that type of thing, about how do you deliver that type of education. So I think, you need to, if you're going to do it, it needs to be targeted. And if that sort of proportion is there, you can probably construct a very effective piece of financial education.
Because there again, it comes back to the resource, because the voluntary sector are very much under pressure. So who would be providing this financial education? And it's not clear in the bill who would.
It certainly shouldn't be linked to discharge, because on these numbers that are available, we don't have an issue with repeat offenders due to lack of financial education.
Sorry.
One very quick point on the discharge. I absolutely agree with Donald. I can't see the rationale for it because inevitably the people that really need the financial education, I suspect, are the people who are, if you like, least deserving of any punishment. They may just be, financially inept in some way, and to actually seem to be punishing them by delaying their discharge seems to me unfair.
About financial education,
I think that's fine. I think we've unless anybody else wants to come in on financial education, I think we've dealt with that.
Right.
So
Okay, thank you very much, convener. Yes, you may have heard some of the evidence in the earlier panel about concerns about the profits made by the insolvency business. And I know you touched on that again when you were talking about regulation. My question is specifically for Alison Anderson. It concerns just an example of what could be viewed as that kind of profiteering from my own constituency. 2 years ago, DG Yards in Dumfries went into liquidation, and Armstrong Watson is the liquidator. Now, it's taken 2 years for Armstrong Watson to come up with any deal for creditors, and creditors, many of whom are living on the margins, they're artists, were you recently told them they were getting 12 pence in the pound, but your hourly rate is £177 an hour. Now, one of my constituents, Rab Wilson, was owed £1,200, and he'll get a payout of £144, which is less than Armstrong Watson charge in an hour. And I wondered whether you considered that fair and perhaps an example of why the industry does need regulated.
Okay. Obviously, the member is entitled to ask whatever question she wants. It is relevant to the subject in hand. I appreciate, Ms Anderson, you might not have come prepared to answer that question today. If you want to answer it, entirely up to you. But don't feel you have to.
Not to, but I could have a discussion with John McAlpine after. Yeah. But there was one very good reason why it took 2 years, and it was all to do with an insurance claim.
Well, I think the details of the case are not of particular interest to the rest of the committee, so perhaps you could discuss that separately. Joan, do you want to ask another question?
No, I just think that that when the creditor gets less than the hourly fee, there's something very badly wrong with the industry.
Okay, I think you made your point, Mr. Norris.
Yeah, I'm happy to address this point, and I'm sure Martin will be as well. listen, I'm a creditor and in lots of cases, and I definitely think that in proportion, I'm going to do a very risky thing now. I'm going to compare Scotland to England and Wales. The proportion of fees in Scotland in trustees are higher, significantly higher than in IVAs in England. So there's got to be something, they're not that different, so there's got to be some reason for it. And I think a lot of the things that the AIB is doing around the reform of trustees will help that. You know, percentage realisations for fees as well is a good thing. So there is pressure going on it. But I think, I mean, you're right to raise the concern about fees, I think. But I think there is stuff that's going on there, and it does concern creditors generally. And I think there are some firms who are better than others. So I don't think necessarily tarring all IPs with the same brush is a valid thing to do.
Yeah, I think just to echo that as well. I mean, fees have been constant criticism for creditors for quite a long time here, and I think that would have come out quite strongly in all of the creditor evidence that came into yourselves. I think the other piece as well is creditors have now engaged with the industry. I think, you know, with this, with the trustee working group, for example, with the regulation, there's a lot more engagement from creditors because, you know, to be fair, I think at any point creditors can try to control fees on cases. They just need to understand their rights and what they can and can't do.
Thank you. McKinnon, yeah.
Perhaps fees should not always be mixed up with profit. There's an awful lot of running costs going into an organisation. Software licences, on average, to be compliant with your regulator, are on average £850 per user. So, whilst fees may be high, profits could also equally be low.
Right, okay, thank you. Dennis.
Yeah, thank you very much. I maybe direct this to Mr Norris because I think you brought up the issue of the moratorium earlier. A lot of people get into debt through, quite often, no fault, it's circumstance. I mean, it could be, as was mentioned before, loss of a job or unforeseen, bills that may have occurred, and really they just, find themselves in a position that they just can't meet these. And quite often the adverts on television get them into a situation whereby they try and have a quick fix and it doesn't work. In general principle, do you support the moratorium and why?
I can answer the first bit very quickly. Yes, I do. And the second point I think I referred to earlier on, it's breathing space. It just allows the debtor to get their head around what they're going into, because it is a fairly complex and, as I say, sort of traumatic experience for them. And it just feels for the reasons why I'm struggling to come up with a definite reason, it just feels right that there's this moratorium up front to allow things to progress, allow things to get sorted out, and for everyone to get their head around it. Yeah. So it's not a very satisfactory answer, I appreciate.
Yeah. So does that enable the process to some extent of money advice education?
Absolutely, absolutely. All these things can be done in that period, in my view.
Yeah, okay. Any other views in terms of the moratorium period?
I think as well, from a creditor point of view, they've sort of worked their own moratoriums to a certain extent. So a lot of creditors now will give debtors breathing space of a certain amount of time before they actually enter a debt solution, where the debtor raises that they are struggling. So I think this is something that is recognised by creditors. I think that's good news for the debtor because, again, I think that the debtor does need breathing space. There's quite a complex process of bringing a lot of things together in a short period of time, and that allows that to happen.
That's good, thank you.
Okay, thank you. Can I ask a question, something we haven't touched on in this panel, but it came up in the earlier panel? And maybe this question's to Martin Pridgeant and Alison Anderson, because you both mentioned this in your written submissions, and this is this question of the 6-month discharge period for the MAP debtors. Why do you think that's inappropriate, Mr Pridgeant?
I agree that for the debtors that meet the criteria of the MAP, that there's very little returns available there for creditors, and therefore what we need to do is try and wipe the slate clean in a reasonable amount of time. I came at it possibly from an anti-creditor viewpoint, actually, for this one, which was actually, I believe it should be 12 months. I believe it should be something slightly longer, and only because I believe from a breathing space point of view as well for the debtor. I don't think 6 months is actually a long enough time to rehabilitate that debtor, take them out of the marketplace, protect them from whatever advertising and sort of loan selling is going on. I think 12 months is a better period to do that.
So you think, yeah, actually the debtor would benefit from the longer period in
I
terms
actually
of
think it's
added
better
protection.
protection. Yeah, better protection
Yeah,
for the debtor to extend that out to a, you know, to a slightly longer period.
Yeah, can I just
Yeah, sure.
is rehabilitation the term? Are we not talking about informing, advising, educating? And if it's rehabilitation, we're not talking habilitation, which is actually a more enabling, a much more positive, a much more positive outcome.
I'd agree with all those words because I think ultimately it takes us to the same place.
Okay.
Okay. Alison Anderson, do you want to add?
Very similar comments to Martin. Just 6 months just is not a long enough time to deal with and give the debtor that protection really that he needs from them as creditors. Because, you know, very often creditors will always continue to get, you know, documentation from creditors, and we need to constantly deal with that, for example. So it's really a practical issue.
Okay, thank you. If there are no further questions to that, I think we can end the session here. Thank you very much to all of you for coming in. It's been very helpful to the committee to get your evidence. If committee members just stay in their seats just for a second, I'm going to suggest that we move item 4 on the agenda up until now, as we'll have some time in hand, and in which case we will go into private session to allow that discussion to take place, and we will at 12 noon have the Minister back in public session. But we'll go into private session now and suspend briefly to allow a changeover. Right, if we can reconvene. We're at item number 2 on the agenda, taking evidence on the Protected Trust Deeds Scotland Regulations 2013 in draft from Fergus Ewing, Minister for Energy, Enterprise and Tourism in the Scottish Government, who's joined by Chris Boyland, Head of Strategic Reform, and Claire Orr, Executive Director, Policy and Compliance from the Accountant and Bankruptcies Office, and Graham Fisher from the Scottish Government Legal Director. Welcome all. Now, before we get into the evidence from the Minister, I have to read this out. ICAS have pointed out there is an error in the text that they supplied to the committee. This is the key statistics in Annex B to the paper that members will have in front of them, and in particular the third subheading, PTDs discharged - trustees fees. The second bullet point states, these figures are based on the actual fee as taken from the Form 7 received by the AIB. The fourth bullet point states, the estimated fee as provided by the trustee in Form 3 when the PDT is registered is often different from the actual fee charged as provided in the Form 7 when the PDT is discharged. Neither Form 3 nor Form 7, however, give details of a trustee's fee, but only administration expenses. While this would include trustees' fees, it also includes the cost of realisation, statutory fees and other expenses of the PDT, which are payable to parties other than the trustee. These statistics should therefore refer throughout to administration expenses, as these are quite different in scope from trustees' fees. Can I thank ICAS for pointing this out? I hope that's clear to everybody on the committee. Absolutely. Thank you. Now, we turn to scrutiny of the regulations before us. Minister, do you want to say something by way of introduction?
Yes. Thank you, Convener. These regulations will deliver a number of benefits. Firstly, they will improve transparency. Secondly, they will ensure that fact-finding fees are not paid ahead of creditors' dividends. Thirdly, they will support debtors who can pay to pay by making the comparison with DAS, the Debt Administration Scheme, much clearer. In one case, on the AIB system, the debtor repaid £3,980.52 over and above what they owed. They could have repaid their whole debt nearly twice as quickly if they had gone into DAS. I'm sure we would all agree, therefore, that we want the right vehicle to be used for debtors who want to pay their debts in full, rather than go into a debt relief scheme. They will also have a positive impact on dividends overall, and perhaps most importantly in some cases, they will end the practice of some trustees taking contributions from a debtor's benefits income. The Scottish Government has had concerns for some time, Convener, about the transparency of protected trust deeds and the way that high costs can sometimes swallow up any return to creditors. And these costs cover fees and outlays, as I think was the point was made a moment ago in your opening errata, if that's what it was. Now, these concerns have been highlighted by organisations such as credit unions, and I've noted, and I very much welcome the support across the board of credit unions for the changes that we are introducing. It can't be right, Convener, surely, that more than a third of protected trustees, more than a third, will pay no dividend whatsoever. That's not what trust deeds were for. It can't be right, surely, that some firms see administration costs increase by more than 25% over the lifetime of a case, and that more than half of the gross receipts gathered in some protected trust deeds should be spent on costs. And yet this is what is happening at the moment. So I'm pleased to say that we are doing something about it. Following extensive consultation with stakeholders, we've listened to views, we've developed a package of proposals which I believe provide a balance between the rights and needs of all parties concerned with trust deeds. In the light of stakeholder concerns, Convener, in relation to the introduction of a minimum dividend for protected trust deeds, we have decided not to proceed with this measure at this time.
but we will keep it under review in the event that the proposed changes do not have the impact that we expect. Let me turn to the measures that are being introduced. We are changing the way that insolvency practitioners can levy their fees for PTDs. They will no longer be able to charge an hourly rate. Instead, they will charge a single fixed upfront fee, augmented by a percentage of funds ingathered. This means that insolvency practitioners will now have more of an interest in the success of the trust deed. We are improving transparency by requiring that creditors be notified of the level of fees that the trustee will charge before they are asked to agree to the protection of the trust deed. And protection of the trust deed means that diligence can't be carried out by creditors on the debtor, and therefore is a sine qua non of the protected trust deed providing protection to the debtor. Creditors will also be asked to approve any increase to the trustee's fixed fee and to approve an annual update on the performance of the trust deed. Where the expected dividend has reduced by 20% or more, trustees will now be required to provide creditors with details of the options available to them. We're excluding outlays incurred prior to the date the trust deed was granted, such as fact-finding fees from the PTD itself. These fees can be quite substantial, Convener, and have been roundly criticised by the money advice world. So these can no longer be charged separately and will now be treated the same as other debts included in the trust deed, and this brings trust deeds into line with the practice in bankruptcy. We're making a determined effort to tackle the lack of transparency and the rising costs of PTDs, and I know that some of our key stakeholders have recognised this. For example, ABCUL, the representative body for our credit unions, have said that, and I quote, "New measures to clamp down on the far too frequent abuses of PTDs by trustees are welcome and vital to make the process fairer." PTDs are an important form of debt relief, but they have to be sustainable, which means that they have to be transparent and offer a reasonable return to creditors. That hasn't always been the case, but I think these regulations will help to ensure that in future it is the case. If not, then we stand ready to make further reforms to these regulations. Like ABCUL, Convener, in conclusion, I think this is both welcome and vital to make the process more transparent and fairer to all, and I hope the committee shares that view. Thank you.
Okay, thank you, Minister, for that introduction. Can I maybe just start by asking, in relation to the evidence that we heard from ICAS and R3, their principal concern, or one of their principal concerns, was about the timing of these changes being brought in, that they were coming in 18 months in advance of the date when the Bankruptcy and Debt Advice Scotland Bill, which the committee is also currently considering, is expected to come into force. Now, this would mean that there would be no harmonisation for that 18-month period in these two different tools, the Protected Trust Deed and bankruptcy. The view of ICAS and R3 is that would mean there would be a significant increase in the number of debtors choosing bankruptcy over protected trust deeds. Is that the Scottish Government's view? Do you expect to see that increase in bankruptcies coming forward?
Well, no, it's not, Convener. I'm pleased that you've asked me that question, because I was, after receipt of the evidence last week that was presented by ICAS, I, at my request, sought and obtained a meeting with both ICAS and R3. I have, I should say, met previously with IP's representatives, I think earlier in the year, to meet these matters, and indeed have engaged regularly with them. I think it's fair to say that I'm no stranger to IPs in Scotland. Not in
a personal capacity, I hope.
And last week I therefore had a very useful session with representatives of ICAS and R3. It was extremely helpful. We had a very positive discussion. We had a full ventilation of their concerns, but we don't share them, and we don't share them for three reasons. And perhaps it would be helpful if I just run through them, Convener, because these are serious points, and you know, we recognise that the IPs operate in a profession where the members are carrying out their duties in accordance with the rules in a professional manner. The cases of abuses are, if any, absolutely minor. We recognise that, as I think was acknowledged by ICAS in communications to you as recently as today or yesterday. So that's common ground, but we don't agree with them in this respect. The first reason is that if we look at England and Wales, there is an equivalent solution there to PTDs called individual voluntary agreements, or IVAs. The usual practice in IVAs, Convener, is to run for 5 years. not 3, 60 monthly payments. So if ICAS's argument were correct, then we would have expected, would we not, that IVs would have dropped in popularity and importance, dropped in prevalence, dropped in the usage, dropped in their uptake. That hasn't happened. In fact, the opposite has happened. IVAs have been a success, despite the payments being 2 years longer than bankruptcy. Now, this is the central tenet of ICAS's case, that if you have a discrepancy of the period of total payment, 36 months as opposed to 48 months, then debtors will automatically go for 36 months, not 48 months. Well, it's 60 months in England, and the take-up has increased of IVAs from 1,928 in 1990 to 49,039 in 2011, from 1,900 to 49,000. So, you know, if the proposition is that the debtors will always go for the cheapest option, that's just not the case. And I think, although IVAs aren't identical to PTDs, so we're not saying they are, they're equivalent broadly to PTDs in Scotland. And therefore, the evidence actually shows very clearly that a longer period of payment and paying more will not actually discourage people from choosing the option equivalent to PTDs in Scotland and England called IVAs ahead of bankruptcy. Now, why is that? Well, there's a number of reasons for that, and I have still a glimmering recollection of this from practice as an insolvency, as a solicitor operating in these fields for many years before I was elected. And these reasons, therefore, are very real. Firstly, debtors choose to enter into a trust deed rather than bankruptcy because they perceive there's a lower stigma. This is very, very important to understand. A great many people do not want to enter into bankruptcy. They do not want to say, I'm a bankrupt. Now, rightly or wrongly, convener, in some ways we feel that the idea of a stigma is wrong and something that we try to remove because, you know, many people who enter into bankruptcy do so of no fault of their own because of circumstances in their lives, redundancy, bereavement, and so on and so forth. So there's no broad brush approach of generalising that all people who are bankrupt are rogues. That is just not the case. And that stigma, therefore, is something that we feel is something that we would like to tackle. But be that as it may, there is still a view out there that a great stigma attached to bankruptcy. And therefore, many people who believe that they can make a substantial contribution, give their creditor something back, want to do that. Maybe they can't pay it all back, but they want protected trust deeds because the stigma is not so great as associated with bankruptcy. Now, there are other reasons. I think these perhaps are maybe lesser, although they may be more important for some cases, convener, but there is a fee of £200 to enter into bankruptcy. There is no fee of entering into protected trust deeds. So there is that immediate financial cost of entering into bankruptcy, which is not the case with PTDs. And also, and this can be very important for some people, there are terms and conditions of some debtors' employment that does not allow them to continue to be employed when they are an undischarged bankrupt. So if you cannot get a job or risk losing a job because you enter into bankruptcy in that status, well, plainly, convener, you know, you have a very strong interest in PTDs as a possible means of avoiding that cataclysmic and disastrous consequence to your life. So I think for a minority of people, admittedly, but for a few people, that is the case. And of course, convener, there's a much wider argument, which is that, you know, a lot of people in Scotland want to pay their debts in full. They don't want to take the easy option or the cheap option. They don't want just to get off with it all. They want, through moral probity, a duty to pay back creditors, to pay their debts in full, and we want to encourage that. Now, if the argument of ICAS was correct, that people just choose the cheapest option, well, nobody would pay off the debts. They would just all go into PTDs or sequestration, depending upon their choice, would they? But that's not the case. And in fact, not only is it not the case, but I'm delighted that that the incidence, the use, the take-up, the numbers going into DAS are rising, thanks, I think, in part to the changes that have been made during my period of stewardship of this particular portfolio area of responsibility. That's good news, convener. We want to do that. And some people go into PTDs who actually should be going into DAS because they can pay the debts off in full. So we want to encourage that as well. So I do respect the views in conclusion that the IPs have formulated. I wanted to take the time myself to update myself, to acquaint myself with their arguments, but having had the opportunity to do that, to reflect with officials here, I would urge you that for the reasons I've set out, the consequence which they say will have a significant incidence in the numbers going into PTDs as opposed to sequestration is unlikely to occur.
Okay, thank you, Minister, for putting that on the record. Any members wish to come in with questions? This point, Dennis Robson.
Good afternoon, Minister. I think maybe on that point as well, in terms of debtors wanting to pay their debts, sometimes that longer period is, although it's going to cost them more, is perhaps more acceptable to them on a payment basis because they feel it's more affordable. Whereas, you know, the lesser time is something they might struggle with. So indeed, actually extending the time, like the IVA in England, for instance, it does enable people actually to pay off their debt. Would you agree with that?
Well, that was a view expressed, I think, in large part, actually, by ABCO, who I think sought that the PTDs should be allowed to run for at least 5 years relative to the debt. So we had representations, actually, that the period should be equiparated with that south of the border. After listening very carefully to the views of all stakeholders, including ICAS, we thought that to strike a balance between debtors and creditors needs 4 years seemed to us to be correct. But I understand why ABCO on one side are saying 5 years might be more appropriate, and ICAS on the other side say 3 years may be more appropriate. We are adopting a middle view, if you like. But I do understand the point Mr. Robertson makes, and I think it has validity.
Okay, Mike.
Yes, Minister, I was hoping you could clarify something. I've been led to believe that the Common Financial Tool is a bit kinder to people who are on benefits by not, extracting payments from them. Do you agree that in that regard, at least that the Common Financial Tool is superior to some of the alternatives?
Yes. We do believe very strongly that the Common Financial Statement will help considerably, and it is right that we introduce it now. Perhaps it might help if I explain, Convener, that the Common Financial Statement arose in discussions and the need for a single common financial tool was agreed following meetings of a working group made up of representatives of ICAS, the IPA, the free money sector, the banking sector, credit union sector and AIB. And the approach here was to adopt one single method of computing how much people should pay from their income. This has been something which has been looked at for a long time, and I think the desirability of having a single method is self-obvious, is self-explanatory, because one wants to avoid inconsistencies which have arisen in the past, with some people paying vastly more than others. And that has been a feature, even of late, actually, in some instances that I've seen in years past. So I'm pleased to say that following the bankruptcy reform consultation, 25 stakeholders supported the CFS, the Common Financial Statement. Only 4 supported an alternative model. And Mr. Mackenzie is quite right in that one of the differences in the CFT is that it prevents money being taken from people whose sole income is on benefits. Now, I don't think it's really right, morally or financially or in any other way, that money should be taken from people's benefits to pay contributions in this way. That is something that will not happen under the CFT. I want to make it clear that I'm not suggesting that that's something which has happened on a widespread nature, but I think from memory it's Regulation 21 of the regulations actually that specifies that this will be the case, not the CFT itself. In other words, we have set out the law that in Scotland we will not see people whose sole income and benefits having some of that predated to pay for creditors. Now, I understand that ICAS aren't happy with the CFT, or they may not wish it introduced at the current time, or either position. I'm not entirely certain of that, but so I hope I'm not misrepresenting them. But we feel very, very strongly that this common financial tool is a good thing. It should be introduced now. It is morally correct. It also, incidentally, has been supported by such organisations as the British Bankers Association, the Finance and Leasing Association, major utility companies, and building societies and other bodies. So it's got a widespread uptake, I think, Convener. It may be the UK government will follow suit and copy what we're doing in Scotland. I'm not quite sure about that, but I hope they do. We think that this is a major potential step forward, I think, for kind of fairness and equity and transparency in the law of debt in Scotland. I don't know if there's anything else my colleagues would like to add to that, or if we've covered everything. We've covered everything.
Good morning, well, good afternoon, Minister. My question is around possible conflict of interest with AIB and the trust deeds, where, you know, such conflicts they could be avoided. There's a suggestion that there'd be a protected trust deed review board set up. Just who would be on that, and how could we be sure that there wouldn't be this conflict?
Right. Thank you very much for that question. Again, this is, to be fair, a point that has been raised by ICAS, and therefore one that we wanted to respond to in detail and treat this matter with respect, as we have done with all of their other representations. And the accountant in bankruptcy, Rosemary Winter-Scott, is acutely aware of the need for independence and impartiality in undertaking these new functions that will arise following the implementation of these regulations and the forthcoming bankruptcy bill reforms. So I am pleased to tell the committee that the Accountant in Bankruptcy's Operational Policy and Compliance Team, that's the OPC, will be charged with undertaking decision reviews and issuing directions to trustees. Now, I mention that because the OPC is completely independent from the parts of the organisation that are directly involved in administering bankruptcy, the supervision of PTDs, or managing the provider contract for the firms acting on the AIB's behalf. The AIB has recently undertaken a reorganisation of teams to physically distance the OPC from the operational teams involved and to further reinforce this independence. And therefore, you know, I think in theory there can be arguments that a conflict of interest will occur. But I hope that by mentioning these operational arrangements that the Accountant of Bankruptcy is to put in place, that I will be able to persuade members of the committee that although there are apparent conflicts of interest, they will never become real conflicts of interest. Of course, I'm aware that the large accountancy firms very often themselves are not unfamiliar with issues relating to conflict of interest, acting as many of them do for a huge number of commercial companies, many of them operating in the same sector. So I hope that as accountants will recognise that it is perfectly possible to discharge conflicts of interest by making appropriate internal arrangements themselves, so the Accountant of Bankruptcy will be able to do so. And it should be said, the Accountant of Bankruptcy has no financial interest of any sort in any of these matters, because no one in working for the Accountant of Bankruptcy has any direct financial return from any of the undertakings that they are involved with. Finally, to answer Margaret McDougall's point, the PTD board will include a wide range of representation, which will include creditors and credit unions and IPs.
Okay, so that will be independent from the accountancy and bankruptcy then? These will be individuals who will be brought in to sit on that board?
Well, there'll be a large representation on the board, which will include representations from creditors, credit unions, IPs, from all appropriate stakeholders in the area, and therefore it will have that broad range of interests represented therein. And I have 100% confidence in the Accountant of Bankruptcy in these matters. I do not believe that they will give rise to any difficulties whatsoever.
Clear over.
Something to that. I think perhaps there's some confusion around about the role of the PTD Review Board as distinct from AIB's powers of supervision. So AIB will conduct the powers that it has in supervision as set out in the regulations, but separate from that, to aid us with consideration of further changes to PTDs and the operation of the system. That is the role of the Review Board, and that's why we're very keen that that does include representatives of all parties who are impacted by protected trust deeds.
So how many people would be on this board then? I mean, what's the percentage of independent people to AIB?
To AIB, well, there really only will be the Secretariat from AIB. It will be chaired and led by AIB, but all of the members as part of that group will come from sectors who are impacted by protected trust deeds.
Okay, thank you.
Thank you. question? If not, can I just go? Sorry, Alison. Sorry.
Thank you. Just, I'd like to revisit the contribution period. The discussion. ICAS have said that they're concerned that there's a lack of evidence that a 48-month contribution period will result in a net benefit increase to creditors. I mean, they're concerned about the impact on creditors. I just wondered what analysis had been done of the impact on creditors and also, of course, on debtors before this decision to settle on a 4-year period was made.
You want to answer that specific point, Claire?
There hasn't been a specific analysis as such of the 4-year period. When we consulted on the changes for the bill and also the regulations, we had started from a position where we looked at a default position of 8 years for people to go into the debt arrangement scheme and pay back for 8 years if they could do so in that time. The consultation told us that that wasn't something that there would be general support for, but there was support for a period of 6 years and other years within that. Therefore, the 4-year period has come from that wider discussion around about in keeping with the principle of those people who can pay their debts should pay their debts. So this is the first stage in the levelling of the contribution period across all of the solutions in order that there isn't a perceived advantage over one solution than another in terms of encouraging people who can pay to pay. Some of the analysis that we have of protected trust deeds that exist just now, for example, a number of them do already last for longer than 4 years. Payments are made for that length of time already, so there is some evidence that already supports debtors paying for that length of time.
Okay. Thank you. Thank you, Convener.
Thank you. Mr. Burnley?
Good afternoon, Minister. Good afternoon. Just one question. As I understand it, the IP has argued that the trust deed being a voluntary arrangement between the debtor and the creditors had a right to object to the trust deed to prevent it becoming protected if it didn't meet their particular needs. But there was the comment that the provisions in the draft regulations give the accountant in bankruptcy the power to overrule decisions in the trust deed. Does that not undermine the position of creditors, in your opinion?
Well, we believe that the AIB should have powers to intervene, but only where there is evidence that the trustee is not fulfilling the requirements under the legislation. The AIB would only refuse to record a trust deed as having protected status where the conditions contained in the regulations have not been met. This includes where the income and the expenditure of the debtor is deemed to be excessive and no valid explanation has been provided by the trustee. Now, we would not expect, if the CFT is being used, that situation should occur. It would also occur where the AIB has evidence that the debtor has not cooperated with the administration of the trust or has not met their obligations in terms of the trust deed. Indeed, we believe the powers given to the AIB could be helpful to the trustee in circumstances where creditors do not agree to a request by the trustee for an increase to the fixed administration fee, Convener. In these cases, the trustee can apply to the AIB for the increase to be agreed. The AIB will look at the request, and where they find the increase in fee will result in a benefit to the creditor, the AIB will agree to the increase to the fee. So actually, the powers of intervention, although rightly raised by ICAS, and I can see the point they make in general, interference, use of the powers would be occasional, would not be the norm, but the exception we expect, and in some cases it may actually be of assistance to the trustee.
Okay, thank you.
Just, Minister, just go back to something you said in your opening remarks about the comparisons with the situations in England. Is it not the case that in England access to bankruptcy is much more restricted than it is in Scotland, and the fee is considerably higher than the £200 that's charged here?
Well, it may well be the case that is so. I'm not an expert on the matters. I'll turn to my colleagues in a minute, but I would just make the point that there is a difference in England of 2 years of contribution payments. That's a very substantial difference. One would expect, this is the key point, that if ICAS are right and people simply go for the cheapest option, then they would go to some lengths to find the cheapest option, would they not? But not only has that not been the case, but the numbers of entering into IVAs have increased massively, and therefore, you know, the figures quite clearly contradict the proposition that that people will opt for the option which is cheapest, which involves them paying least to the creditors, making minimum contributions over the shortest period. The evidence from down south just doesn't indicate that that's the case, and indeed that is just not the view that is taken by the credit union world, if I can put it that way, either. And bear in mind, convener, that, you know, unlike ourselves, money advisors are dealing with people who have debt problems all the time, every day, all day, don't they? And in any event, the second set of reasons that I gave about personal choices for choosing PTDs over bankruptcy also, I think, are pretty valid. I don't know, in response to your question, however, if officials have got anything to add about your point that bankruptcy may not be similar in the nature to Scotland so far as access is concerned.
I think it's generally similar in every other way apart from the fee. The fee is higher, as you say, it's around about between £600 and £800 for the fee in England, but I understand that the access to it is similar broadly to the arrangements that apply here.
I just wondered really whether, you know, given that we've already heard in evidence as a committee that the £200 fee is a barrier for many people in Scotland, whether the £60, £800 in England was a much more substantial barrier, and that perhaps explains the high uptake of IVAs more than some of the other factors.
There are other things that happen at a UK level. There are a number of organisations who sometimes meet the application fee for people applying for bankruptcy in England, so some different arrangements apply which may cancel that out, if you like.
Margaret?
Timing of this regulation. The draft regulations presuppose that the bill will enter the statute book as it is. If any changes are made to the proposals in the bill during the parliamentary process, then the regulations will have to be amended. Can you assure us that that will be the case?
Well, I don't. I mean, I expect, as with all bills, convener, that you know, there will be through the parliamentary passage some form of amendment to the bill. I would think it's personally unlikely that there will be significant amendment should the committee be minded to pass these regulations here today on the essentials, if you like. But it's a perfectly reasonable point that Margaret McDougall has made, and I can only say that were that situation to arise, then we would of course address it at that time. But we do believe that there are very strong reasons for introducing these measures now. I mean, if we delay 18 months, this would mean that the changes as far as impact in PTDs would not come in until 2019. We want to avoid that. You know, we want people now to be clear that money will not be taken from their benefits, which could still be the case were these regulations to be rejected today. We want to make sure that the arrangements to move away from an hourly fee, whether it's £96 an hour or slightly higher, as some of the cases that we've got appear to indicate, to a fixed fee will be introduced. We want to promote the further dissemination of information about the performance, the relative performance of firms that do this work, and there already has been some information put out into the domain, which I think the committee has, and which shows that there's a considerable variance in the estimated return to creditors and the actual return to the creditors, albeit it's early stages yet, and we will, as years go by, obtain further information and a fuller picture. So these regulations have enormous benefits. We do not think it's right to postpone them. That's why we're introducing them now, convener, rather than waiting a period of potentially 18 months before we introduce them. We think that the society as a whole, debtors individually and creditors, should benefit from these provisions, and that's why we will be moving them this afternoon.
Thank you.
Any further questions? If not, we will move on to the formal debate on the motion. I remind the Minister's officials they can no longer participate on the record, though they may speak to the Minister or pass any notes to him. I would invite the Minister, if you would please, to speak to, if appropriate, and move the motion S4M 07759 that the Protected Trust Deed Scotland Regulations 2013 be approved.
Yes, I'll just refer to the arguments that I've put, I think, convener, without labouring them, so I move accordingly.
Thank you. Do any members wish to speak or ask the Minister a question? If not, I will put the question, and the question is that the Economy, Energy and Tourism Committee recommends that the Protected Trust Deed Scotland Regulations 2013 in draft be approved. Are we agreed?
Agreed.
Agreed. We are agreed. Thank you. Okay, now we have to produce a report on this by the 11th of October, which is 2 days away. Are the committee agreed that we will produce a short factual report and agree to have it published by then? We'll need to bring it back to committee. Okay. Fine. Thank you very much, and that concludes business. Thank you very much.